offensively and replace it with stuff.
Say impolitic, and then let's strike the words, and then I'd like to be able to say the words that I would prefer is impolitic and fine, and I hope that we will continue to debate in a collegiate way. Is that okay?
Perfect.
Yep.
We will resume regular order. The gentlewoman from Texas, Ms. Jacksonville, continues to be recognized.
Thank the chairman for the consultation. I think I've made my point, and I ask unanimous consent to revise my comments, Mr. Chairman, such that I would strike the word offensive and indicate impolitic and unkind, and hope that we will move forward in a collegiate manner.
Without objection, thank you, Ms. Jackson-Lee. Appreciate that. We will now conclude our debate on the ISA amendment.
Mr. Chairman. Mr. Chairman.
The gentleman from Colorado, Mr. Polis, is recognized.
Thank you. I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. You know, there's been a few in the debate of this particular amendment, which I support. There's just been a few mischaracterizations that I do want to address. First of all, online piracy is damaging to all of us. We've all suffered from it. We also suffer from it in terms of the additional costs that we have to pay for our own entertainment. I've suffered from it professionally, having run a chain of movie theaters, having a website that was ripped off and had content copied across the internet with very few ways to drop it. So there have been some questions about, you know, motivations and who's committed to that. I think everybody's on this committee is committed to addressing internet piracy. I think that many of the opponents of this bill are strongly committed to reducing internet piracy. It's just a question of including everybody in the discussion. There's been some discussion about whether the internet is somehow a lawless place. It's not. The same laws apply to crimes committed on the internet as via any other mechanism. If you sell drugs via the internet, if you sell illegal drugs over the telephone, if you sell them on a street corner, you're going to jail. The internet is never an excuse for anybody to violate criminal law, copyright law, any type of law. It is a communications technology. It's a way that people talk and exchange data. You know, does coordinating over the telephone make it easier for someone in New York to commit a crime with somebody in California? Yeah, it probably does. Does communications over the internet make it easier to commit certain crimes? It probably does. Does it also allow detection mechanisms and give additional abilities to investigators that they didn't have absent the internet? Yes, it does as well. There's been some discussion of in the personal context the word offensive. I would apply the adjective offensive to these particular provisions of this bill that this amendment is eliminating, primarily blocking DNS. To explain this as a metaphor, it's akin to there being a crack house in a neighborhood where crimes are being committed. Now, the correct solution is you go in and you bust the crack house, arrest it, condemn it. That's a direct response. What instead we're trying to get at here is basically changing the street signs in the whole neighborhood in the hopes that people have a more difficult time finding the crack house, leaving it there, but also making it more difficult to get to all the nearby houses and the nearby streets. Screwing up everybody's GPS system, resulting in a lot of lost people and frustrated people, many of whom had no intention nor desire to ever commit an illegal act, nor have they committed an illegal act. I think that we as a committee can create an excellent work product in this area, and I think Mr. Issa has an excellent idea with the Open Act, but there are others that are complementary to that. That's not a mutually exclusive approach where that has to be the end-all. I think there are excellent ways that we can make progress on this issue, but it's critical to hear from the experts. And I think Ms. Lofgren rightfully pointed out that overwhelmingly Internet engineers that are disinterested in the sense that they are not on a particular payroll to create a particular opinion, disinterested experts, overwhelmingly, I mean, I would almost say universally, by the hundreds, by the thousands, believe that this is the wrong mechanism for enforcement. Is it possible to find 3 that might have another opinion? It probably is, especially if they're under retainer to have that opinion. The resume of the one gentleman that had the contrary opinion sounded more like the resume of kind of an IT professional of an intranet than it did somebody who necessarily is fully versed in the architecture of the Internet. But again, I think it's critical for this committee to resolve some of these unresolved issues, to get at what we all want to get at, which is protecting against piracy and counterfeit goods in a way that doesn't, first of all, isn't counterproductive and doesn't enable counterfeiters and pirates, as some provisions of this bill do, by driving further underground those who would violate, leading to the potential of distributed DNS becoming a mainstay rather than alternative decentralized DNS. And likewise, doesn't have a lot of collateral damage among those who are law-abiding, have law-abiding goals, and are job creators as well. So I hope that this committee does take the time to work through this, and certainly we're doing that in the process of the markup. I don't believe any of the remarks I've heard have been dilatory. They've all been very constructive. But additional information that needs to be provided through members, both formally through hearings as well as informally from experts, I think would help move this process forward and result in a work product that, if it doesn't have universal support, will have stronger bipartisan support in this committee, and it also is A, more likely to become law, and B, will be a better law for the country, both in terms of reducing piracy, and in terms of reducing the potential collateral damage to other areas.
Would the gentleman yield for just
if I can have 30 seconds more with unanimous consent, I'll yield to the gentleman from California.
a quick point? The point that you've made is an essential one
Objection. The gentleman is recognized for 1 additional minute.
Thank you. I yield to the gentleman from California.
for everyone to understand. Mr. Ice's amendment is a proper one. Getting back, we've had a lot of discussion, but the fact that we would try and disappear a site on a search engine doesn't make the site go away. The site is there on the internet, and you can try and disappear it from Bing, but you're going to find it some other way. You can type in the IP address. You can go to a search engine that is not within our jurisdiction. The site is still there, which is why this amendment is prudent, and why the manager's amendment is a mistake. It will have collateral damage, but it also will not work. And I thank the gentleman for yielding.
The gentleman yield?
Would the gentleman yield?
I do. I yield to the gentlelady from Texas, and then who else requested?
The chair.
Okay. Well, I'll be happy to yield to the chair first then.
I thank the gentleman for yielding, and I'll issue additional time. First of all, if you permit me, I just want to put 2 letters in the record, one from the National Cable Telecommunications Association and one from Comcast in support of the legislation. But the point I wanted to make is that the argument that this won't always work is certainly true. It's also true of the follow the money approach. There are financial institutions outside the United States and customers outside the United States who will do business with a foreign site that is selling U.S. copyrighted works of U.S. authors or other products that we can't reach. So, yes, we need to have as many tools as possible to combat this. And I also want to say that in reaching out to the tech community, we have gotten red lines, we've gotten proposals, we have made changes in the manager's amendment, and we welcome more. We are going to accept some of the amendments that are being offered today. I'm going to support them. I don't know if the whole committee
This would be
will.
a good start.
This one will not be one. But I will say to the gentleman from California that if there is an alternative out there that the tech community or individuals within it or companies within it wants to offer, that would be a better way for them to make a contribution about how to fight this crime on the internet and not put all the burden on the financial services industry and the advertising industry. I've been looking for that all year.
The Open Act.
I yield back.
Yeah, I thank the gentleman. I think if I perhaps have 45 seconds, I'll respond briefly and then yield to the gentlelady from Texas. I believe that we can do better. I believe that these mechanisms produce more collateral damage than they do correct protection. There are sins of commission and sins of omission equally as valid.
Without objection, the gentleman is recognized for an additional 30 seconds.
I thank the chair, and it's critical to do it in a way that is more effective with less collateral damage. We can get there. Clearly, if people weren't at the table before, they are at the table now. They're aware of this markup. I'm convinced that everybody will be at the table to come up with a better solution. I yield to the gentlelady from Texas my remaining time.
I totally agree to the gentleman, and I would also thank the chair for acknowledging that some of our amendments may be considered, which speaks to the fact that we can get to a common ground. I just had a dialogue on the question of the word offensive. I want to make it very clear that one of the issues I raised about this legislation is whether or not there's a First Amendment protection. I do not deny the First Amendment of Mr. King, by the way. It's impolitic and unkind, but First Amendment issues are extremely important. I hope that they are addressed. I have a First Amendment amendment, and just simply say, can we have that kind of dialogue? I say that to the chair because he's a strong sponsor of it, that would get us to the point in this legislation that we could answer the concerns that have been expressed by many of us. One, dealing with national security, First Amendment, and the infrastructure of the Internet as to whether it fits under the scheme of this legislation. With that, I yield back to the gentleman.
I believe my time has expired.
gentleman.
I yield back.
The question occurs on the amendment offered by the gentleman from California, Mr. Issa. All those in favor respond by saying aye.
Aye.
Those opposed, no. The
Ayes
opinions
have
there,
it.
the noes have it.
Mr. Chair, on that, I request a recorded.
Gentleman requests a recorded vote. Clerk will call the roll.
Mr. Smith? Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Lundgren? Mr. Lundgren votes aye. Mr. Shabbat? Mr. Shabbat votes no.
Aye.
Mr. Issa votes aye. Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chiefitz? Mr. Chiefitz votes aye. Mr. Griffin? Mr. Griffin votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? Mr. Ross votes no. Ms. Adams? Mr. Quayle? Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Berman? Mr. Berman votes no. Mr. Nadler? Mr. Nadler votes aye. Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Johnson? Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? No. Ms. Sanchez votes no. Mr. Polis?
Aye.
Mr. Polis votes aye.
And how am I recorded?
Not recorded, sir.
I'll vote no.
Mr. Smith votes no.
Are there other members who wish to be recorded? The gentleman from California, Mr. Gallagly?
Mr. Gallagly votes no.
Gentleman from Wisconsin?
Aye.
Mr. Sensenbrenner votes aye.
Gentleman from Texas, Mr. Gomert?
Mr. Gomert votes no.
Gentleman from Ohio?
Mr. Jordan votes aye.
The gentleman from Tennessee? I voted no.
Mr. Cohen votes no.
You know, that's a smart thing to do. Are there any other members? The gentleman from Georgia, Ms. Johnson.
Mr. Johnson votes yes.
The gentlewoman from California.
Not recorded, ma'am. Ms. Chu votes no.
Are there other members who wish to be recorded? If not, the clerk will report. The gentleman, the clerk will suspend. The gentlewoman from California. Oh, the gentleman from Michigan. No.
Mr. Conyers votes no.
Clerk will report.
Mr. Chairman, 12 members voted aye, 22 members voted nay.
Majority having voted against the amendment is not agreed to. Are there other amendments?
Mr. Chairman, I have an amendment at the desk.
Gentlewoman from California, Ms. Lofgren, is recognized to offer an amendment.
It's Lofgren 51. It's number 6 on the roster.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Ms. Zoe Lofgren of California. Page 16, line 23, strike or. Page 17.
Without objection, the amendment will be considered as read, and the gentlewoman is recognized to explain her amendment.
Mr. Chairman, the amendment makes clear that operators of domain name servers do not have an obligation to block a foreign website if it would impair the security integrity of the domain name system or their systems or networks. It makes network and DNS security and integrity an explicit defense for a service provider against legal action by the Attorney General to enforce any obligation. Now, I think this is entirely consistent with the existing savings clause in your manager's amendment for network and DNS security and integrity. It simply ensures that the issue is fully considered by the courts at all stages of the new legal proceedings created by the bill. The amendment also prevents a court from assuming that there must be some way for a service provider to block a foreign website based upon the requirement in Section 102C1A. If there is no way for the service provider to block a website without impairing network security and integrity, then it should have no obligation to do so, and I think the amendment makes that very clear. Now, the amendment makes explicit, as I said, the savings clause, and without the amendment, I think a court is likely to read this bill and assume that Congress must have intended that there must be some way for a service provider to block a foreign website. I do not believe that this is a safe assumption. We have had a lot of discussion here this afternoon, and I suspect we are going to have a lot more discussion about the technical issues that face us. While it is true that we have had no hearings and no testimony on the technical issues, we are not without some access to information on the subject. As I mentioned, and I would like to ask unanimous consent that we place into the record my letter to Dr. Leonard Napolitano and his response to me on the issue of cybersecurity.
Without objection.
I simply asked, Dr. Napolitano is chair of the lab. It does both classified and unclassified research in cyber. Clearly, he doesn't want to insert himself into the policy discussion, nor did I ask him to do that. I merely asked that he provide his technical and expert advice to me and to the rest of the committee on how whether this would work, number one, and whether it would impair cybersecurity. And as you will see by the letter, he indicates first that it will not work, and second, that it would impair national security and cybersecurity. We've also received information, as I've referenced before, from Mr. Stuart Baker, the former Assistant Secretary of the Department of Homeland Security and the former General Counsel of the National Security Agency, who has said that domain name servers might have no ability to block a website without impairing key internet security measures. And I would like to ask unanimous consent to place in the record the article by Mr. Baker, as well as his article that was published subsequent to the manager's amendment, pointing out that the manager's amendment continues to endanger national security.
Without objection.
If that is the case, if these experts are correct, a service provider should not be held to any obligation under Section 102. I believe that the manager's amendment recognizes this fact by placing it in the savings clause, but the amendment that I'm offering ensures that the commitment to protecting network and DNS security is given proper consideration by the courts who will be applying the new law. Now, I had suggested, and I appreciate that the chairman had allowed Mr. Issa to offer his amendment. Had his amendment been adopted by the committee, this amendment would not be necessary. I would say further that it really isn't an optimal situation to have dozens of district courts deciding what the cybersecurity policy of the United States is based on individual litigation. That is actually something that should be established by the executive branch with ample input from the legislative branch, most specifically committees that have not been consulted on this legislation, namely the Intelligence Committee, the Armed Services Committee, and the Homeland Security Committee. But given that Mr. Ice's amendment failed, I do think it is important for those who have discerned that the remedy envisioned in the bill puts their network or system at risk, that they have an opportunity to offer that as an affirmative defense. And I would also ask unanimous consent that we put into the record the December 9th letter from Dr. Steve Crocker, Dr. David Dragon, Dan Kaminsky, Danny McPherson, and Dr. Paul Vixie, objecting to the analysis provided by Mr. Castro, who was referenced by my friend from Virginia earlier in the proceedings, and pointing out why his allegations are, as a technical matter, incorrect, and why they will undercut cybersecurity.
With that objection, and the gentleman's time has expired. Are there other? The gentleman from California, Mr. Ice, is recognized.
Thank you, Mr. Chairman. And I rise in support of Amendment number 6. I think it clarifies what we've all been talking about. The Lofgren Amendment makes very, very, very clear that if, in fact, this is going to hurt, something we don't know, we debated it for an hour on the last amendment, but if we don't know, we certainly should have a clause to say we agree to do no harm. And, Mr. Chairman, I know that that you had said that you were prepared to accept some amendments. Are you prepared to accept this one, Mr. Chairman? Mr. Chairman, you said you were prepared to accept some amendments. My question would be, since this one only takes effect if, in fact, we would harm the Internet by enacting that portion, are you prepared to accept this amendment?
I am not prepared to accept the amendment.
Then what amendment could you possibly be prepared to accept?
Well,
Would the gentleman yield?
Actually, we are
Not yet.
getting to a few shortly. Well,
Okay, well, I'll try to...
I hope we get there shortly.
Well, I doubt it, but I will tell you that I find it hard to believe that any of us, that not just the 12 who voted for the last amendment, but any of us...
Would the gentleman
Would the
yield
gentleman
for
yield?
1 minute?
Yes, I would yield to the chairman.
The gentleman from Utah has an amendment coming up shortly that I intend to accept. And so therefore, the gentleman...
Well, I suspect he'll tweet a happy thought on that one. But reclaiming my time, I would appeal, and I'll yield in a moment, but I'd appeal to everyone, if we cannot put provisions in this law that say, please bear in mind, if it will do harm, don't do it, then what can we put in the way of protection? That's all Ms. Lofgren's amendment does. It is so narrow and so non-controversial that I believe the gentleman from California, Mr. Berman, would like to support it. Is that what you're seeking time for? I'd yield to the gentleman. Don't disappoint me.
Well, depends on what your expectations are.
A yes would be good.
But is it an expectation or a hope?
Hope and change is all I'm asking for.
But this is an interesting illustration of all the discussion, and I think sincere discussion about dangers, security dangers. The manager's amendment said perhaps one could have read this as saying the Attorney General or a party in a private right of action could require something that would harm the security of the Internet. And the manager's amendment shifts this to a court. But here's an amendment.
Well, but reclaiming my time, you know, if you're a plaintiff's trial lawyer and you're looking for money damage, you say, look, the law was very specific. It required this to be done.
That's my point, is this is written so the defendant, not the 100 people at some national laboratory or engineer, the defendant claims the magic words that if I took an action, it would impair the security or integrity of the domain system.
Right, and
this doesn't sound like it gives it to the court to determine whether that's a legitimate.
Well, reclaiming my
assertion.
time,
Simple assertion
reclaiming
by the
my
defendant.
time.
Would the gentleman,
I would
Gentleman
yield
from
to the gentlelady
Gentleman
from
from California, Mr. Issa has the time.
I'd yield to the gentlelady from California.
I would note that although I'm sure sincerely offered, that is not a correct statement of the amendment, because this goes to the system operator, not to the infringer, that has an opportunity to offer this defense. And that, I strongly preferred Mr. Issa's amendment, because I thought it actually puts the onus for network security where it would belong, which is not dozens of district courts, but the United States government that has responsibility for cybersecurity. That amendment having failed, I do think that the system operator should have the opportunity to provide this affirmative defense, and it is not the infringers. And I thank the gentleman for yielding so that
Thank
I can
you.
clarify.
And reclaiming my time, I understand that many people want to consider potentially Google, Yahoo, Bing, and a host of other companies, Facebook, as infringers. But I don't think it's helpful to say that just because an entity is asserting a claim of danger to the Internet, of failure, that denial of service can and has caused Internet operators for years, that somehow this is the old expression, the pot calling the kettle black. The fact is, this is about a legitimate right to defend, to say, I would do this, but in the case of this particular case, here is a harm offset. Please tell me what I can do in the alternative. And I would only say, in closing, that that is a nature of a demand we're making on an entity that is not, in fact, an infringer. The entity we're coming to is somebody who we say is in some way facilitating an infringer, and they should be treated much more balanced, as much more like the witness to a crime than, in fact, a criminal. And I think that's one of the key points is we are asking for cooperation and help with people who are not the criminals, but are, in fact, witnesses to the crime.
The gentleman's time has expired. I inadvertently recognized the gentleman from California out of order a minute ago. Would like to go back and recognize the gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. The gentlewoman's amendment creates an overly broad requirement for a service provider to consider first the effect on a foreign network or site operated by the foreign rogue website. Provision designed to tie the hands of service providers and diminish the effectiveness of this provision in the bill. The manager's amendment, as was noted by the gentleman from California, Mr. Berman, includes a strong provision to ensure that court orders are not granted if they would affect the integrity of the domain system or would require service providers to modify their network, software, or facilities. This amendment diminishes the overall effect of the provision, and therefore I oppose the amendment.
The gentleman yields back the balance of his time. The gentleman from Colorado, Mr. Polis, is recognized.
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. Again, I think that this amendment is an excellent compromise. Again, I too preferred Mr. Issa's approach to strike the relevant section. But I would hope that this clarity would have stronger bipartisan support, because there has been a lot of discussion here in this committee during this markup about whether or not and to what degree there is a threat that would impair the security or the integrity of the domain system from the enforcement provisions of this bill. And that's one that many of us would like to gather additional information on. But it seems to me very reasonable and very safe to simply include language in the bill that provides an affirmative defense where we don't require that any entity take an action that would impair the security, integrity of the domain system or the system of network. And in fact, we're punting, but we are doing it in a way where at least it provides a hook in the legislation where that can be worked out by later authorities. I would hope that we would, again, through statute, not impair the security or integrity of the domain system, but at the very least, well, not without an affirmative defense. We would by providing an affirmative defense, as Ms. Loft,
affirmative defense.
it is. It's in the affirmative. It says a defendant in an action may establish an affirmative defense, and then this is one of the categories, if I'm not mistaken, of affirmative defenses. Is that correct?
That's correct.
Looks to me like it says, would you yield just for a second?
I would be happy to yield. As one of the non-attorneys on this committee,
I see.
would be happy to yield.
Number on page 16, triple I,
Sure.
limitations, a service provider shall not be required, and then it adds this condition. It doesn't look to me like that's an affirmative defense. It looks like that says if the service provider concludes, and who knows whether, what that process is, he may conclude that something that's in his interest would impair the security. It's not something, an affirmative defense that goes to a court.
I thought we were referring to court orders here. I'll yield to the gentlelady from California.
If you take a look at page 16 and 17 of the manager's amendment, this is a remedy provided to the service provider. It's not the infringer. And it basically would provide that the savings clause, it says the same thing, would be permitted to be offered as to bar this activity. So if the savings clause is serious, then we should have an opportunity to have it be meaningful. And that's what this amendment does. And I thank the gentleman.
And if I can just ask an additional question of the lady from California. The second part of this amendment, if I'm not mistaken, refers to page 21, line 16. That is the section that establishes affirmative defenses, and I believe it does add a category of affirmative defense that the defendant does not have the ability to comply without impairing the security integrity of the domain name system.
That is correct, and we'll give you an honorary law degree.
I thank the gentlelady. So again, with response to the gentleman from California, again, it would allow an argument to be made. I would like to do this, but this would have severe damaging repercussions on the security of the Internet, and therefore that's something that the court should take into account. I think very reasonably, again, if this section is going to be in there, I don't want to impugn everybody's motives. I think everybody on the committee believes that we do not want to impair the security or integrity of the domain system. I mean, I don't think that's anybody's intention to do that. I think there's a greater comfort with that if it appears in both areas of the law. We mentioned page 17 and then page 21, which provides an affirmative defense. I'll yield to the gentleman from California.
I see what the part of the amendment dealing with page 21, line 16. Yes. Off the top of my head, looks like it may create that defense. But the previous provision is limitations. A service provider concludes that it does this, and they then don't have to do the what the court has ordered. And what is being sought. So a little time, perhaps putting off this amendment, maybe. I mean, we got to be real careful here.
Would the gentleman yield?
I'll be happy to further yield to the
because I think that's incorrect. This is what the court will be deciding. It's not what the provider will be deciding.
Read the section.
I did read the section, and I wrote the amendment.
Yeah. And the section talks about limitations. A service provider shall not be required under this section.
That's the key limit.
Well, it's always.
And then you add number 6 to take any action under this section that would impair the. Does he have to prove that? Does he have the burden of proving that under the first part of this section?
Reclaiming my time. I mean, it seems to me that this is all subject to a court. I mean, I think that's the point of the limitations. It would be my understanding. If they were all self-interpreted, then this whole bill would be meaningless because they could all argue that they fit under one of them.
And how does it change?
The gentleman's time has expired. Are there other members who wish to be heard on the amendment? If not, the question is on the Lofgren amendment. All in favor say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the no.
I'd like a recorded vote, please.
Recorded vote has been requested, and the clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Goodlatte votes no. Mr. Lundgren? Mr. Shabbat? Mr. Issa? Mr. Issa votes yes. Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Griffin? Mr. Griffin votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? Ms. Adams? Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Amade votes no. Mr. Conyers? No. Mr. Conyers votes no. Mr. Berman? No. Mr. Berman votes no. Mr. Nadler? Mr. Scott? Mr. Watt? No. Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Ms. Waters? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes aye. Mr. Pierluisi? Mr. Quigley? Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Ms. Sanchez votes aye. Mr. Polis? Mr. Polis votes aye.
And gentleman from California, Mr. Gallagher.
Mr. Gallagher votes no.
Gentleman from Utah, Mr. Chaffetz.
Mr. Chaffetz votes aye.
Gentleman from Ohio.
Mr. Shabbat votes no.
Gentleman from Virginia, Mr. Scott.
Mr. Scott votes no.
Gentleman from New York, Mr. Nadler.
Mr. Nadler votes aye.
Gentleman from Illinois.
Mr. Quigley votes aye.
The gentlewoman from California, Ms. Waters.
Ms. Waters votes no.
Gentleman from Wisconsin.
Mr. Sensenbrenner votes aye.
Any other members? Clerk will report.
Mr. Chairman, 11 members voted aye, 21 members voted nay.
A majority having voted against the amendment is not agreed to. Are there other amendments?
I have an amendment.
The gentlewoman from California, Ms. Lofgren, is recognized.
That's amendment number 52 on the roster, number 8.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Ms. Zoe Lofgren of California. Page 15, beginning on line 16.
Without objection, the amendment is considered as read, and the gentlewoman is recognized to explain her amendment.
The existing language of the manager's amendment gives a confusing set of instructions for the mandate on operators of domain name servers to block foreign infringing websites. Subparagraph 1 of the service provider's mandate in section 102C2A initially gives them the power to determine for themselves, quote, the least burdensome, technically feasible, and reasonable means, unquote, to block a foreign infringing website. However, subparagraph II says they must specifically take action to prevent the resolution of the foreign website's domain name. Otherwise, the service provider will not qualify for the safe harbor in that subparagraph and could face further legal action by the Attorney General to enforce the order. I think this has several problems. It will strongly encourage service providers to take actions that are inconsistent with the core Internet security technologies, such as the domain name security extensions, DNSSEC. As we've noted before, 5 leading experts have written that domain blocking as a specific technical means of blocking a foreign website is fundamentally incompatible with security measures for DNS technology. As has been mentioned prior, Stuart Baker, the former Assistant Attorney Secretary for Policy at DHS and former NSA General Counsel, has written that the domain blocking would, quote, kill our best hopes for actually securing the Internet. The Department of Homeland Security, under both President Bush and President Obama, has hailed DNSSEC as the crucial way to improve the overall integrity and authenticity of information processed over the Internet. The General Savings Clause in the bill for networks and DNS security will be worthless here because it won't stop service providers from being forced to take actions that could disable the NSSEC in order to qualify for the safe harbor. Overall, the safe harbor should stay consistent with the basic obligation on service providers. If we're going to force them to block foreign websites, we should give operators of domain name servers latitude to determine how to comply as consistent with their expertise and knowledge of their systems. Now, a lot has been said today. Sometimes all of us who are passionate on the issue engage in animated rhetoric. But to indicate or suggest that major Internet players are doing nothing to combat Internet piracy is simply not correct. I actually asked Google, who is, I think Mr. Issa described as being a piñata at our hearing, how many times they took down sites under the existing DMCA obligation. I was advised that this year they responded 5 million times, and that in 75% of those cases the action was taken within 6 hours of the notification. So to say that a 5 million response within 6 hours is negligent or uninterested, I just think misadvised. It's not correct, and it's doesn't understand the effort that is being undertaken. Does that mean that more should be done? Possibly so, and I think more will be done. But certainly to make this language that's in the manager's amendment of allowing the Internet world to take those steps that are most viable, most technically feasible, will be undercut by the safe harbor provisions that essentially say you got to do the domain name system blocking. That is a problem we've been told by the Internet experts. It will make the Internet less secure. It will, ironically enough, lead to additional piracy when the Internet becomes less secure. So I strongly urge my colleagues to adopt this amendment, and I would be happy to yield to my colleague from.
Well, first of all, let me indicate a refrain that I've been, and thank the gentlelady for yielding, that I've been using constantly, is that there is no opposition. In fact, I'm going to inquire of the lady, do you have a opposition to the prevention of piracy for the intellectual property of this country, or many of those who are advocating for this legislation?
No. In fact, I do think that protection of intellectual property is important. And although we have talked often about the movie industry and the recording industry, and certainly they are wonderfully successful economic engines in our community, they're not the only content providers that suffer from piracy. In my own district, where we have companies that provide software that are also subject to piracy. This is something that is not unique to the entertainment industry. This is something that plagues the software industry as well. The point is we need to use the right tools to cope with this piracy. It is not going to be successful or satisfactory to our country if we make the Internet less secure and end up promoting piracy.
If I could just reclaim my time.
The gentleman's time has expired. I'll recognize myself in opposition to the amendment. The gentlewoman's amendment seeks to strike language in the bill that is important to service providers who will abide by this statute. The manager's amendment does not require service providers to adopt any particular technique to comply with a court order, but provides flexibility for them to determine the most appropriate mechanism. This amendment seeks to frustrate a judge's determination that a site is a foreign rogue website and should be filtered to protect U.S. consumers. The amendment grants a safe harbor to ISPs that choose to do nothing in response to a court's determination. In other words, it gives a safe harbor to those ISPs, whether they've complied with the court order or not. So this amendment is designed to undermine the bill. I urge my colleagues to oppose it. I'll yield back the balance of my time. Are there other members who wish to be heard? Gentleman from, anyone on this side? The gentleman from Colorado.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
So to further address this with the gentlelady from California as well, your amendment would deal with where the subscribers are located to the site, right? Specifically stating that the subscribers would have to be located within the United States. Is that what my understanding? The subscribers would have to be accessed by its subscribers located within the United States. And let me just further ask on that one. What is the goal with regard to the location of the subscribers to the service provider?
I'm sorry, it's getting late. Could you?
Sure. If I'm okay, so again, I believe the language that you're adding. I know we're talking about the language you're striking. Access by subscribers located within the United States to the foreign infringing site that's the subject of the order. So I believe that you're basically saying for a service provider, they would have to, for domestic subscribers, have to maintain a different set of DNS resolution or a non-authoritative name system than for their foreign subscribers. Is that?
Well, it actually deals with the safe harbor incentive.
Sure.
To use one. We're saying in the bill that we're not requiring DNS blocking, but in fact we are, because of the safe harbor that's been created. And I think that's inappropriate, especially given the alarms that we have been provided for by those who are knowledgeable and who have not picked a side in the bill about the damage that this will do. This would try to remove that incentive. I think it would effectively, and would allow the technical means that the experts use to be so used. And I thank the gentleman.
Yeah, and I would also point out that I think that this particular language that you're amending is in many ways short-sighted with regards to reducing piracy by creating a safe harbor and designating certain behavior. It is in fact saying that such behavior is in fact completely acceptable and letting them off the hook, when it could be that there could be other forms of and mechanisms of enforcing intellectual property that service providers should in the future or now be responsible for. However, this one clearly is one that can, I think, cause more problems than it solves. I think that the amendment further, again, highlights the issue of the bifurcation and the stratification of the Internet that this would entail, as many service providers would, in fact, have to maintain across different jurisdictions various forms of resolving domain names. So I think it's a good amendment. Again, I think that the safe harbor provision can be improved through this amendment. I think that this amendment can actually help reduce Internet piracy by providing more of an incentive for innovative techniques to take down offending websites, and I strongly support it, and I yield back the balance of my time.
Okay. Gentleman yields back the balance of his time. The gentleman from California, Mr. Issa.
Thank you, Mr. Chairman. I support the gentlelady's amendment, and I think that the characterization of its not working belies the question of, isn't it potentially necessary? In other words, once again, hasn't the gentlelady recognized a real problem, even if you object to some penmanship, if you will, on the solution? And would yield to the chairman if he wanted to comment on that. I mean, I heard you say that you didn't think it was a good amendment, but do you think there's no problem? Do you think that it's just perfect the way it's written?
Let me refer to the manager's amendment. I think this goes back to the debate a minute ago, too. Yeah, I'm very happy and comfortable with the manager's amendment, but let me reemphasize that the measures that are taken are not going to be determined by the court, and I think there was perhaps a misconception about the underlying manager's amendment a minute ago. It's the service provider that determines what's the least burdensome, technically feasible, most reasonable means designed to prevent access by its subscribers. They are the ones that making that determination. And furthermore,
But don't you limit safe harbor to only a portion of that? So that if, and that's why I'm asking, Mr. Chairman, is I get it that you're saying you're giving them flexibility, and I think
Right.
that was half of the loaf in the manager's amendment.
Right.
But why wouldn't you give them safe harbor for anything which in good faith could reduce or eliminate that, so that they would be able to choose the one that was the most effective? And this is where I think the gentlelady from California was trying to make the point, both in First and now Second Amendment, that if you can't give flexibility and safe harbor for that flexibility, then what you're really doing is saying, this is what we want you to do, and you'll be sued if you don't do it effectively.
the gentleman's time has expired. Let me recognize him for another 10 seconds so I can respond.
I'd ask for an additional minute, Mr. Chairman.
Without objection, the gentleman is recognized for an additional minute.
I yield.
Let me, on so much of this, if individuals have concerns about the underlying manager's amendment, I feel like saying, show me the language. Show me the language that causes the problems that the individuals are worried about, because I just don't see it. And the same thing is true here on page 15 under service providers. I just read a sentence under under AI, under A2, safe harbor, the measures determined by the service provider to be least burdensome, technically feasible, reasonable means designed to prevent, and so forth. That answers the gentleman's question. The answer
but reclaiming my time, there is an additional
If I could
question.
improve it, I'd agree to improve it, but I'm very comfortable with leaving.
Well, I understand you're comfortable, but can't you see where we would be uncomfortable with the fact that the safe harbor is limited? The options are extensive,
Would the
but the
gentleman
safe
yield?
harbor is limited.
Yeah,
Yes,
I mean,
yield.
it's very clear. If you look at page 15, the one thing that gives you safe harbor is the DNS takedown. I mean, that's the problem, which means that in a backdoor way, that's what we're going to require, because it's the only thing that's safe to do.
The gentleman's time has expired. Are there other members who wish to speak on this amendment? If not, we will vote on the amendment. The question is on the amendment. All in favor say aye.
Aye.
Opposed, nay. No. Opinion share, the noes have it.
I'd like a recorded vote,
Recorded
Mr.
vote has
Chairman.
been requested. The clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Aye. Mr. Sensenbrenner votes aye. Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Griffin? Mr. Griffin votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? Ms. Adams? Ms. Adams votes no. Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Conyers votes no. Mr. Berman? Mr. Berman votes no. Mr. Nadler? No. Mr. Nadler votes no. Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Ms. Sanchez votes no. Mr. Polis?
Aye.
Mr. Polis votes aye.
The gentleman from Virginia, Mr. Goodlatte.
Mr. Goodlatte votes no.
Gentleman from California.
Mr. Gallagly votes no.
Gentleman from Ohio.
Mr. Shabbat votes no.
Are there other members who wish to record their votes? If not, the clerk will report.
Mr. Chairman, 10 members voted aye, 24 members voted nay.
Majority having voted against the amendment is not agreed to. We will now go to the next amendment. The gentleman from
I'm back.
California.
Thank you, Mr. Chairman.
Recognized. The clerk will report number 9, ISA 74.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Mr. Issa of California.
Without objection, the amendment will be considered as read, and the gentleman is recognized to explain the amendment.
Thank you, Mr. Chairman. This one is not on the substance of how we do it, but is on the fairness and on the ultimate effectiveness of a unilateral law. And, Mr. Chairman, and I think for all of us who have worked in international trade, all of us who understand how you get cooperation on intellectual property protection, by precluding the Attorney General from bringing action on behalf of a non-U.S. person, what we say, in effect, since I've been very clearly told, nowhere in the world is there a law similar to SOPA. As a result, if you take non-U.S. persons out of this, they all have some other country in which they can enforce their laws, or at least insist that something that protects our intellectual property or their intellectual property in their country, then the State Department has a real opportunity to bring a reciprocal agreement. So until a country were to do the same thing for us that we're doing for Americans, there's really no reason to give them a benefit to come to America and sue or gain some benefit when in fact their own country doesn't do it, or they should do it in their own country. And just to be, I don't want to say over the top, under the current law, a Russian infringer could come here to protect himself against someone infringing against them, well, we would have no capability of reaching out to his site in Russia. And it's exactly that. You know, you're looking at bad actors around the world who would not be reachable on behalf of what they do, but in fact would come here for monies on behalf of what they could. So it's very narrow. It only affects the question of, this is clearly about domestic collection. It should be for domestic copyright. And I understand that the Supreme Court has very clearly ruled that a corporation is a person. So I'm not kidding myself. If there's a U.S. corporation that owns the copyright, this would not lock them out. It would only be literally a non-U.S. citizen or a non-U.S. corporation that has the copyright. And I'll close with this. If somebody is a non-U.S. person and they want to have their royalties go to the Cayman Islands, why should we spend a whole lot of time trying to collect for them until or unless there's some sort of reciprocal agreement with one or more of these countries that these individuals might be in? And so although my light never came on, I would reluctantly yield.
Would the gentleman yield?
I would yield.
The gentleman is once again revealing his honesty. You're right, the light did not go on. However, the gentleman's time is awfully close to expiring.
I would yield to the gentleman quickly.
This gentleman over here.
That gentleman. The gentleman who tweets so seldom.
I thank the astute gentleman from California for yielding, and I just posed this question, and I think maybe you've addressed it, but I wanted some clarity for my own purposes, and I think for the committee, and that is that as we look at foreign countries who are, some of them seem to be in the business of stealing U.S. intellectual property, and we're pressing them to bring civil charges and criminal charges against those perpetrators, and you said a reciprocal agreement, which perhaps is your answer. But does this amendment, if it goes on, does it weaken our ability to press for that kind of relief in foreign countries?
I think that's a very good point. As long as the copyright is held by a U.S. corporation, they would qualify. If it is a foreign corporation essentially saying, please collect the money so I can ship it outside the country to a non-U.S. person, no. But what I was trying to say, that although it would not stay within the limitations of this committee, if I had made it a State Department carve-out, I didn't want it going to another committee like the Trade Committee over at Ways and Means. So within the jurisdiction of this committee, we're only saying don't pay. Very clearly, there could be a bill authored or a treaty offered that would create those entitlements. So it really is an inducement to say, if you do it, then we will modify our law so that you get the benefit in our country as long as you come from a country that's in the compact. But today there are no countries that would reciprocate, so there's really only a reason to say non-U.S. I'd say non-U.S. except Israel and Japan if they had similar laws. They don't.
The gentleman would continue to yield?
I'd continue to yield.
And I thank the gentleman. Then I just ask this, is it the gentleman's position, as it is my position, that we need to do all we can to honor all intellectual property rights so as to encourage other countries to reciprocate in kind as a matter of policy, law, and philosophy?
Well, reclaiming my time, if it's soon expiring, in principle I do, but remember, the Attorney General, U.S. resources used to collect on behalf of a non-U.S. entity does not seem at all reasonable to have us expend those under this particular statute. And remember, all somebody has to do to qualify would be to put their copyright in the U.S., in a U.S. corporation, and then the benefit of their royalties would flow, at least in small part, to the taxpayers who pay for the Department of Justice. So we're not asking for a lot other than we should not be enforcing on behalf of foreign entities and foreign copyrights, because it's not really a U.S. copyright if, in fact, it's held completely outside.
The gentleman's time has expired. The gentleman from Virginia, Mr. Goodlight, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I think the gentleman from Iowa, Mr. King, has touched on what I think is the flaw in this amendment, and it's a serious flaw. It creates a terrible international precedent. For example, the Chinese and the Russians could use this amendment as a template for a law to discriminate against foreign companies and decree that they will no longer enforce IP laws on behalf of foreign companies, meaning U.S. companies doing business in their countries. And yes, we're in there asking them to help enforce our laws in a variety of ways, and we're asking them to do that so we can ship money out of Russia and China that our companies have sold there back to the United States to help create jobs in this country. So I think the gentleman's intent of wanting to force greater international cooperation is a good one. I don't think this amendment accomplishes it. In fact, I think it could have just the opposite effect. Further, the Attorney General does not bring actions on behalf of U.S. persons or non-U.S. persons. The Attorney General brings an action on behalf of the United States. The Attorney General only brings a case to enforce U.S. law. This amendment would dramatically alter the role of the Attorney General and law enforcement in enforcing the laws of the United States. This could be an unprecedented legislative effort to limit the actions that law enforcement officials can take to curb intellectual property theft by foreign websites. And remember, the primary remedy in this legislation is an injunction, is blocking. It's not actually getting funding, but we have other tools that we use in the United States and other tools in other countries we attempt to use to enforce those laws. I don't want to set a precedent by saying we're going to have a law in the United States that only protects U.S. persons or U.S. corporations and then find that China or Russia uses that same template.
Would the gentleman yield for a
in
question?
Those countries where we're facing these enormous serious problems with enforcement of intellectual property rights.
Question as to your statement on the Department of Justice. Then would you say that the Attorney General basically can go and bring a case where the copyright is not objected to, the copyright comes from another country and is held by another entity in another country, sua sponte? What you're saying is you don't need a plaintiff, you don't need an injured party. But in fact, we do have an injured party who's going to come to the Department of Justice and say, hey, I'm the copyright holder, and I understand that one of our complaints was that the original bill didn't say you had to prove you had the rights to the copyright, but somebody's going to start off by saying, this is my motion picture, please enforce on behalf of me.
Undoubtedly, but the United States is obligated to make a decision based upon what's in the interest of the United States. You can't go to the Justice Department and say, I want you to make a decision to bring this action. They have to make a decision independent of those requests about whether it is in the best interest of the United States to do that.
And all we're saying is that you do your best interest is on behalf of American corporations and American persons.
I think the objective is a good one, but the consequences, if that same principle were applied in the countries where we are facing very serious infringement, and in some of those countries, your only recourse is to go to the government and say, you need to enforce your intellectual property laws against these companies because they are harming our companies conducting business there. And if they say, well, we only do that for Chinese owners of copyrighted Chinese materials, we're going to set a bad precedent here that's going to make this problem worse rather than better.
But the whole basis for this law is that you have these countries in large amount are doing just that. They're refusing to do anything for you. Look, China protects Chinese companies. Look, China does not protect American companies. China will allow a military operation to steal your intellectual property and sell it on the Internet.
I'm not expecting the Attorney General of the United States to devote most of their time to what you're trying to prevent them from doing altogether. I'm just trying to prevent a bad precedent from being used by the Chinese or the Russians to say, well, you guys won't, your law says you won't enforce our intellectual property rights under this particular provision, therefore, we're not going to exercise our laws to protect the U.S. copyright in China.
If the gentleman would further yield, I'm only limiting that copyright has to belong to a U.S. entity. It's a very narrow requirement. And in fact, a copyright in China would only be enforced on a Chinese copyright. They wouldn't enforce a U.S. copyright in China anyway. So if you had a Chinese copyright and they said you've got to have a Chinese corporation in order to have standing to do that, it has to belong to a Chinese person or a Chinese corporation, that wouldn't be an unreasonable request. I've done business in China, and that part is not unreasonable. And in fact, that's our whole point, is we know this is going to be expensive.
Well, reclaim my time. I don't think we want to establish the precedent that in the United States, in order to get the protection, a U.S. citizen owns it, because we do have U.S. citizens who own intellectual property rights in China and in hundreds of other countries.
As I have, but you really don't want to have a president shutting down the Internet either.
Mr. Chairman?
The gentlewoman from California, Ms.
I'd move to
Hoffman.
strike the last word.
The gentlewoman is recognized for 5 minutes.
I think, on balance, Mr. Ice's amendment should be supported. And let me share my thinking on this. It is true that our courts are open to any plaintiffs who want to file, and it is also true, as Mr. Goodlatte points out, that the Attorney General operates on behalf of the people, the American people, not an individual plaintiff. It is also true that you cannot have a problem unless there's a copyright that's infringed. That's the basis of this entire action. We need to put this amendment in context. There is not another nation on earth that is considering doing what we're doing to the Internet. None. In fact, it's worth noting that Europe is now moving exactly in the opposite direction. The week before Thanksgiving, they intervened and said you cannot do this because it interferes with the privacy rights of Internet users. So essentially unless we adopt Mr. Ice's amendment, what we're saying is that we are going to adopt the most extraordinarily draconian enforcement mechanism in the world that will make sure that American citizens, as much as possible, there's lots of ways to get around it, but the intent is to preclude Americans from having the ability to utilize the Internet to access sites, and that we're going to use that extraordinary remedy for the whole world because no other country is willing to adopt this scheme. I think that is troublesome to me, and I think it's something that we should not do and that Mr. Ice's amendment would prevent. I would note also that in the manager's amendment, it points out that there's no additional appropriations to the Department of Justice for this could be enormous new mandate. So what we're essentially saying, unless we adopt Mr. Ice's amendment, is that we are going to divert the Department of Justice for going after other criminals of all sorts to benefit copyright holders in other countries who cannot get a remedy similar to ours in their own country. I just think that would be extraordinary for us to do, and especially at a time in falling budgets. And absent Mr. Ice's amendment or something very like it, I don't see a way around it. I don't know if Mr. Ice would like additional time, but I would be happy to yield.
Again, I think the gentlelady hit the nail on the head. There's no money for this. This is an expensive expansion of the Department of Justice and use of the federal courts. And in fact, earlier in the day, we were talking about the fact that there would be selective enforcement. And we're simply saying if you, for example, make a movie and then put it in the Cayman Islands Corporation, well, fine, great. But you're not going to be first in line or second in line. As a matter of fact, until the Cayman Islands enter into some kind of an agreement, you're not going to be in line. Now, as the gentlelady said, and I tried to say in my opening remarks, you can transfer this back so there's a real asset here and an ability for those funds, if collected from yours, to flow into the U.S. and thus pay corporate taxes or some taxes. But if you're going to circumvent U.S. entity, which is a great many of these movies and records, they've done that. They really have. There's a lot of intellectual property that is deliberately held outside the U.S., then you shouldn't be in line for the Department of Justice's expansive program to do this. We're not asking a lot. We're simply saying this should not be a priority, and this was the cleanest, simplest way to do it. And, Mr. Chairman, I certainly would have picked other language if there'd been an opportunity to work with staff directly on picking other language. But we did. We gave you the chance to pick on our amendments. We never had the opportunity to have our amendments critiqued and improved so they would be acceptable to the chair. And that's something that my staff has always sought to do in the past, and is regrettable that we didn't really get to do that this time.
Reclaiming my time, I would just note that this amendment really is a companion measure to the amendment offered by Mr. Shabbat earlier in the day, with the same rationale. And to not adopt them both, I think, would be inexplicable. And I thank the gentleman for drafting his measure.
Mr. Chairman?
The gentleman yields back her time, and the gentleman from Colorado is recognized.
Move to strike the last word.
The gentleman is recognized for 5 minutes.
So I appreciate the discussion between Mr. Goodlatte and Mr. Issa. I too share a fundamentally globalist approach. Real progress on this issue needs to be multilateral. There's no doubt about that. Mr. Issa's Open Act, I think, moves us in that direction. And on its own, this particular amendment would, as Mr. Goodlatte pointed out, seem to be inconsistent with that. But I think you have to look at the broader context. What's inconsistent to the principle of global cooperation is the underlying bill, the manager's amendment. If other countries were to follow the precedents of the United States and have separate internets under the pretense of intellectual property protection, now again, justly wielded in many cases, particularly by our own government. Even our own government makes a few errors. Our Attorney General, as Mr. Issa has pointed out, is not infallible. And I believe even more so in other countries with regard to the potential for abuse, the potential for selective enforcement of intellectual property for a whole host of reasons, all of which are invalid: political, ideological, economic, etc. So to the extent that this narrows the scope of the discretion, the prosecutorial discretion that the Attorney General will have, I think it's a good amendment. I questioned the Attorney General when he was here last week on how he would use his discretion on this in this area. And he responded that there is obviously impossible to prosecute everybody. I will be offering an amendment in a similar vein with regards to pornography. But this one, I think, makes a lot of sense. Again, it amends an underlying bill which is offensive to the concept of international cooperation on intellectual property issues. So the extent that the bill is already offensive in that area, it does not in and of its own raise any protectionist red flags or anything else that would impede our ability to work on these issues with other countries. And on the net positive side, it provides less discretion and more guidance to the Attorney General for how he would use the vast new powers that would be given to him under this bill. I'm happy to yield back the balance of my time.
Thank you, Mr. Pullis. The question is on the amendment. All in favor say aye.
Aye.
Opposed, no. No. In opinion of the chair, the noes have it. Amendment is not agreed to.
Mr. Chairman, on that, I'd ask for a recorded
Recorded vote has been requested. The clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Goodlatte votes no. Mr. Lundgren? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. Pence? Mr. Forbes? Mr. King? Mr. King votes no. Mr. Franks, Mr. Gomert, Mr. Jordan. Mr. Jordan votes aye. Mr. Poe, Mr. Chaffetz, Mr. Chaffetz votes aye. Mr. Griffin, Mr. Griffin votes no. Mr. Marino, Mr. Marino votes no. Mr. Gowdy, Mr. Gowdy votes no. Mr. Ross, Mr. Ross votes no. Ms. Adams, Mr. Quayle, Mr. Quayle votes no. Mr. Amadei, Mr. Conyers, Mr. Conyers votes no. Mr. Berman, Mr. Nadler, Mr. Berman, Mr. Berman votes no. Mr. Nadler, Mr. Nadler votes no. Mr. Scott, Mr. Scott votes no. Mr. Watt, Mr. Watt votes no. Ms. Lofgren, Ms. Lofgren votes aye. Ms. Jackson Lee, Ms. Waters, Ms. Waters votes no. Mr. Cohen, Mr. Johnson, Mr. Johnson votes no. Mr. Pierluisi, Mr. Quigley, Ms. Chu, Ms. Chu votes no. Mr. Deutsch, Mr. Deutsch votes no. Ms. Sanchez, Ms. Sanchez votes no. Mr. Polis,
Aye.
Mr. Polis votes aye.
The gentleman from Texas? No. Gentleman from California? Mr. Gallagher?
No. Mr. Gallagher.
Gentleman from Arizona?
Mr. Franks votes no.
Gentleman from Nevada? Mr. Amadei?
Mr. Amadei votes no.
Gentleman from Texas, Mr. Poe?
Mr. Poe's voted no.
Yeah. The gentleman from Texas, Mr. Gomert?
Mr. Gomert votes no.
Clerk will report.
Mr. Chairman, 6 members voted aye, 24 members voted nay.
Majority having voted against the amendment is not agreed to. I'm prepared to recognize the gentlewoman from California, but I was going to ask her if this amendment that is on the schedule is not very similar to the amendment 2 amendments ago, Lofgren number 52, similar to Lofgren 53.
Actually, this is broader, but
Okay.
it does not. I would like to offer the amendment.
Okay, the gentleman is recognized to offer an amendment. And the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Ms. Zoe Lofgren of California. Page 15, strike line 3 and all that follows.
Without objection, the amendment will be considered as read, and the gentlewoman is recognized to explain the amendment.
Mr. Chairman, this amendment would strike the authority that the bill gives to the Attorney General to order Internet service providers to block foreign infringing websites, although it would preserve the obligation upon search engines, payment networks, ad networks, and the like to block foreign infringing websites. Now, why offer this? I suppose hope springs eternal that the facts of the DNS blocking will ultimately prevail in one of these amendments. As has been said before, the filtering mandate is not going to reduce in any significant way online piracy. The domain blocking is, as I pointed out in the Safe Harbor amendment I offered earlier, really the only clear way for service providers to safely carry out the obligation in the bill. But it is incredibly easy to circumvent, even for people with absolutely no expertise. Even the members of this committee could circumvent this. As I mentioned when we discussed the search engine issue, when the domain name is blocked, the site that is blocked doesn't go away. It's still there. And how do you get there? You can simply type in the IP address, such as 00.000.123.123. Type that into your browser instead of the domain name, and it's just as easy as punching in a telephone number. It will take you directly to the website. Alternatively, you could use your computer, and again, this is not hard to do, even a 10-year-old could do it, to use a different domain name server, such as a foreign server located outside the United States. It is not technologically daunting. I was talking to one of the members across the aisle last week who said, in fact, his 10-year-old did this. So to say so easy a 10-year-old can do it is not an exaggeration. Further, a quick software download could actually automate the process. And I will have an amendment later about software, but the point is, anyone who wants to reach a blocked site in the United States is going to be able to do that, even if the bill passes with the mandate to filter Internet tracking. And in response to domain blocking, we can be absolutely certain that criminal websites will register themselves under hundreds and thousands of new and shifting domain names, and the Attorney General is going to be playing an endless game of whack-a-mole, and he'll never be able to keep up. Now, that's the downside, why we should not do this, why this makes no sense to do. But as I've mentioned on discussing the other amendments, there's collateral damage. In addition to this not being an effective tool to combat Internet piracy, it will also promote Internet piracy by making the DNSSEC less secure, and it will make Internet stability and security more difficult. We had 5 leading DNS engineers and Internet security experts from VeriSign, from Georgia Tech, and elsewhere earlier this year that wrote that the domain name filtering system in SOPA raises serious technical and security concerns. The manager's amendment does the same. As Mr. Sensenbrenner mentioned in his opening remarks, there's an additional problem with the domain name scheme envisioned in the manager's amendment, and that is First Amendment concerns. Leading scholars, as well as the American Civil Liberties Union, say that this legislation will not survive constitutional scrutiny as introduced, and the provisions targeting DNS servers and search results will have an overbroad impact on protected speech. We have seen that already in actions that were taken by ICE earlier this year, and we will see more of it if this bill is adopted without deletion of this section. Further, and I want to make sure that I'm clear with my friend from California, Mr. Berman, I'm not suggesting that copyright enforcement is the equivalent of actions taken by China and Iran. It's not. But the technology being used is precisely the same. And if we go down this road, we are going to have a much more difficult time having the high road, insisting on an open Internet, as our State Department has done so effectively. So I do think this amendment is an important one. It will go a long ways to curing problems in the bill, and I'm hopeful that we can adopt it. And I see, Mr. Chairman, that my time has expired.
The gentlewoman yields back her time. The gentleman from Virginia, Mr. Goodlatte, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, the gentlewoman's amendment strikes the DNS blocking provision in the bill, similar to the amendment offered by the gentleman from California that we debated very extensively earlier. I read from parts of statements from 3 experts on Internet security about the appropriateness of it. In fact, in some instances, the need for DNS blocking. But the only difference between this bill and this amendment and Mr. Ice's is that his also took out the provisions related to search engines. We didn't discuss that as extensively, but since hers doesn't affect that, I don't think we need to discuss it here. The DNS provisions in the bill are limited actions taken by the Attorney General in federal court. The manager's amendment has addressed a number of concerns and ensured that service providers would only be asked to take these steps in ways that are technically feasible and reasonable, and which don't jeopardize cybersecurity or First Amendment concerns. And so for all of those reasons, I oppose this amendment as I did the other, and I yield back.
Mr. Chair.
The gentleman yields back the balance of his time. The gentleman from Colorado, Mr. Polis, is recognized.
Thank you. I move to strike the last word.
The gentleman is recognized for 5 minutes.
Again, you know, when looking at kind of notorious infringers and violators and criminal sites, we use the Pirate Bay example. Another one that has come to the attention of some in Congress as well is Silk Road. Now, to even view Silk Road, you need to use the Tor network. Its domain is .onion with a long domain. This is a site where you can buy and sell illegal drugs, illegal content, far worse than a Pirate Bay, quite frankly. It has a wide variety of illegal activities that are on there. And fundamentally, this enforcement language would have zero impact on it. Its addresses are not actual DNS names. The .onion TLD is not in the Internet DNS root, and in fact requires local appropriate proxy software to be installed, which is very simple. Anybody can download this browser, and install it. Very simple. And in fact, would be completely outside of the enforcement mechanism of this bill. What would, again, likely happen with regard to this bill is other sites that aspire to be outside of the reach of this bill would convert to .onion or the many other mechanisms that function akin to distributed DNS, either using Tor to achieve a degree of anonymity or elsewhere. And I don't see how that advances the fight against copyright infringers. The further that the bad actors that are out there, that we all agree are out there, are driven underground, the further they are driven from the reach of the law. And we do, fundamentally, in fighting piracy, have the law on our side. There are many more viable enforcement mechanisms that we can establish without the collateral damage that this committee has learned and has discussed, and there's some question about, and many on this committee have expressed an additional desire to learn about as well. But when you have something that won't achieve its desired goal, and again, that's already clear because there are already many violators who, even though there's not yet a reason to, already don't use the DNS system, and you're basically saying to many sites, if this became law, that are infringing, none of them would use the DNS system. You would also have many sites that are afraid of incidental infringement that choose to use alternative DNS systems, whether it's .onion or another form of reconciling Internet names. So again, many negatives. I think this committee should take the time to learn about the exact threat to security and potential increases to piracy that can arise under this bill, and doesn't accomplish the desired and stated goal of actually disabling access to the infringing sites. And again, I don't think anybody's argued it disables access. As Ms. Lofgren said earlier, if somebody can simply type in the ITP address, as I use the example of the crack house in a bad neighborhood, instead of going after the crack house, you're just taking down street signs in the area and hopes people can't find it. But I want to point out that even as an alternative to IP addresses that might be hard to remember, alternative naming structures already exist. It's not a question of if they arrive. They already exist that are not even covered in this law. So I support the amendment, urge my colleagues to vote yes, and yield back the balance of my time.
I thank the gentleman for yielding back his time. The question is on the amendment. All in favor say aye. Opposed, no. No. Opinion share, the noes have it. The amendment is not agreed to. We will now go to the next amendment to be offered by the gentleman from Utah, Mr. Chaffetz.
Mr. Chairman, I have an amendment that's designated as number 186.
Clerk will report the amendment.
Amendment to the Smith Amendment offered by Mr. Chaffetz of Utah. Page 14, insert
Without objection, the amendment will be considered as read, and the gentleman is recognized to explain his amendment.
Thank you. My concern, Mr. Chairman, is that if this bill were to become law, that that there would be perhaps low-level people within the administration there at the Department of Justice who would not necessarily have the unchecked balance, if you will, to relegate what is essentially a death penalty for a site. By taking down a site, you are essentially putting them out of business. And all we're trying to do in the spirit of this is try to say that it needs to be at a very senior level that we make these types of decisions. There have been mistakes made clearly within the Department of Justice and within ICE and other organizations. We have to limit the chances that these types of mistakes will be made. And so I'm offering this amendment. I appreciate working with you, Mr. Chairman, and others. I know that Mr. Watt has a particular concern about these as well. What I would like to do at this time, in order to make sure we get this right, there have been some concerns that perhaps there are other names or titles within the Department of Justice that should be added to this. And so at this time, what I'd like to do is work with you, Mr. Chairman, if the bill were to move forward in reconstituting this amendment in order to make this necessary.
Would the gentleman yield before he withdraws the amendment?
Yes.
I just want to say the gentleman from Utah, all of his amendments are well motivated, but I particularly agree with this one, and we will work together to refine the language, but we will get to the result that he and I want, which is to sort of elevate the decision making and make sure that the individuals making the decisions are qualified and the right people to do so. So I appreciate the gentleman's attitude.
Thank you. Reclaiming my time, I'd like to yield to, yes.
I appreciate the gentleman yielding, and I think he has raised a concern that I would also raise in the next amendment that's to be considered. The problem is I think his amendment is substantially broader than mine. I was trying to get only to DNS blocking as a higher level decision by the Attorney General, which is, and I was trying to get there because that was the area in which all of the national security concerns had been raised. I think your amendment actually is too broad, and I'm glad you're about to withdraw it. And I won't offer mine either, but because I think we can all work together to reach the objective that we're trying to reach. My objective is to have the highest level decision made when you're talking about national security only. And my amendment was a lot more limited, I believe, than yours, although we were actually in the back trying to figure that out when your amendment came up. So
reclaiming my time, so I'm going to yield to the gentleman from Colorado.
I strongly support the amendment. Again, I think the fewer people have these vast powers that we're giving, the better. But in response to Mr. Watt as well, I think that it doesn't solve this issue of a threat to national security. That's not something that Justice Department prosecutors at a junior or senior level are equipped to, nor should they be experts in, which is why many of us have concerns on the underlying bill. However, given those other elements of the bill, I think to the degree that we can have the authority centralized with a few people rather than every state's attorney general or every regional attorney general running around using it, I think that's a very good development. I will support the new iteration of the amendment as well. But it does not address the issue that Mr. Watt raised about national security concerns.
And reclaiming my time, Mr. Chairman, I don't know that I would necessarily totally agree that it should be confined to just national security. What I'm concerned about is you have people with First Amendment rights, with these are their businesses, their livelihood, and therefore I want to make sure that it's relegated to the highest level so these decisions are made at the highest level, because you're essentially taking away their livelihood, their ability to communicate, and that's why I think it needs to be at such a substantial level.
The gentleman yield?
Yielding, yes.
Just to be clear, the problem with that is that it takes so long in that process. But I think we all are concerned that we get the right level of decision making here, and I think the appropriate course for both me and you on your amendment now and my amendment, which is the next in the sequence, is for both of us to continue to work together to make sure that we reach the proper approach and not make a mistake. So I think we get we're all in agreement on that.
Will the gentleman further yield for just one additional suggestion, if the gentleman
Yes.
may? I would also suggest to Mr. Watt and Mr. Chaffetz that this consultation also involve a senior official at DHS or somebody on the security side, because that truly, no matter where you go in the AG's office, that is not within their charge or ability. So I would hope that there would be consultation as well at DHS.
That might be appropriate.
Point well taken, Mr.
Thank you,
Chairman.
Mr. Chaffetz, and the amendment is withdrawn. Are there other amendments? The gentlewoman from California, Ms. Lofgren, is recognized.
I have, it's 13 on the roster, Lofgren 55.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Ms. Lofgren of
Without
California.
objection, the amendment is considered as read, and the gentlewoman is recognized to explain her amendment.
The bill on page 22 provides that a product or service designed or marked for the circumvention or bypassing of measures described in paragraph 2, etc., is prescribed. What this amendment does is states that a product or service that allows Internet users to circumvent domain blocking and other Internet filtering techniques will not be restricted under this bill if those technologies were designed to circumvent blocking or filtering carried out by foreign governments. Now, why would this matter? All over the world, repressive governments like China and Iran are censoring the Internet using various technological methods to block certain websites from reaching their citizens. Some of these methods are the same as what a court would impose under this bill. What has the United States done in response? Well, various computer software and other tools allow Internet users in repressive countries to evade the censorship imposed by their government. And it turns out our government, the United States government, has funded the development of some of these tools so that the people of China and Iran and other repressive regimes can have access to the global free flow of information and freedom of speech. In fact, some of those tools were utilized in the Arab Spring so that individuals could actually have access to information on the Internet. Those very same tools that we have worked to devise, that we've funded to develop in some cases, are the same tools that could also be used by Internet users in the United States to circumvent the blocking of a foreign infringing site under the bill. If we ban them, we would also deprive Internet users in other countries the means to fight back against censorship by their repressive governments. I think it's important that the language in the Mr. Smith's manager's amendment be clarified to ensure that this does not happen, and my amendment would do that in a rather simple way.
Would the gentlewoman yield?
I would be happy to.
I put this amendment in the category of the amendment we just considered by Mr. Chaffetz. I do think that you and I and others involved could write language that would address your concerns, and I'm happy to do so if you would consider withdrawing the amendment.
Well, I'm mindful that, with all due respect, Mr. Chairman, the last time I did that on the patent bill, there was, in fact, no opportunity and there was no follow-through to actually do that. So I'm a little bit nervous about...
Don't let that be a precedent. That was the exception.
Charlie Brown in the football, you do it once, but you don't do it again.
Well, I'll make you a deal. If we don't get it right this time, then you'll have a legitimate point.
Okay, Mr. Chairman, I think clearly we're not going to finish this bill tonight. So I will withdraw, and maybe our staff can talk and reserve the right to offer it again at the end of the ledger.
We can work on it tonight and try to get it tomorrow. Appreciate the gentlewoman withdrawing her amendment. She continues to be recognized for the purposes of offering an amendment.
Mr. Chairman, I have 14 on the ledger. It's Lofgren 59, but I actually would prefer to offer number 41, Lofgren 56, in its stead.
The clerk will report Lofgren number 63.
41.
Oh, 41, pardon me.
41, yeah. That's the number we agreed to. It was miscategorized.
And that's in lieu of Lofgren 63?
Oh, wait a minute. don't have that.
It's on the roster at 41, and it's locked.
Yeah, okay. To be clear, it's on the roster at 41, but it's Lofgren 56. Does that make?
This is, the clerk will report Lofgren number 63, is that correct? No, 41?
56.
66.
Yeah.
56.
At 56, it's 41 on the roster.
41?
Yes.
Lofgren number 41. And is this a substitute for another amendment or not?
I'm sorry?
Is this a substitute for another amendment?
Instead of 14. I think we might have actually worked something out.
They won't be off.
On 41.
In any case, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261.
Without objection, the amendment will be considered as read, and the gentleman is recognized to explain the amendment.
The point of this is to eliminate facilitation as a basis for domain seizures under 18 U.S. Code 2323. The definition of a foreign infringing site under Section 102 is based on the existing authority that the Attorney General claims to seize domestic domain names under existing law. Here's how it works under Section 102. If a domestic website could be seized under existing law, then its foreign equivalent could be subject to being blocked under the new remedies in Section 102. The problem is that the underlying authority to seize domain names in 18 U.S. Code 2323 is itself contested and I believe flawed. In the past 2 years, ICE and the Department of Justice have used this authority in unprecedented ways to shut down websites with no effective due process. They've seized merely upon obtaining a warrant signed by a magistrate based on probable cause. There's no notice, no opportunity to contest. It's entirely an ex parte procedure. Pending litigation in the Second Circuit is challenging these seizures on First Amendment and due process grounds. In that case, the government seized the domain name, domestic domain name, of a Spanish website that had never been sued or prosecuted for any violation of copyright law. Now, we don't know whether that site is in fact guilty of an offense, but that's the point. There should be due process to make that determination before a website which constitutes online speech should be shut down. Other domain seizures by the government have been even worse, and I'm sure the members will recall when the Attorney General was here a short while ago, we raised the issue of a hip-hop blog that was seized, and there was never a contested proceeding. It was ex parte on the part of the Department of Justice. In fact, the proceedings were under seal, and the department refused to even provide the order to the owner of the website. They did that for an entire year before saying sorry and giving the website back to the owner 1 year later. So I think that's another reason why this rush markup is unfortunate. It doesn't allow us to get the bottom of abusive seizures that are the model for the new authority in this bill. One major problem is that the existing language allows the seizures of domains based on the facilitation of copyright offenses by other persons. I think the meaning of this is ambiguous. It's open to abuse and, in fact, has been abused. The government has seized search engines and other websites based on the legal theory that merely linking to an infringing file elsewhere on the Internet can be the basis for a federal criminal offense. And it's not clear what level of criminal intent is required from the owners of the seized domain name. It's not entirely clear from the definition of 102 whether the facilitation of offenses by others can be used to designate a website as a foreign infringing site. However, it is my understanding that this is the intent of the authors of the bill. We shouldn't extend the mistake Congress has already made in creating this problematic language as the basis for seizures, and instead, my amendment would fix the problem at its source, limit the extraordinary remedy of domain seizure without due process of law to websites that are actually violating the relevant criminal statutes with specificity. I think that this is an important clarification. I would be happy to yield to my colleague from Texas.
I'd like to narrowly focus on what the gentlelady, thank you for yielding to the gentlelady. I'd like to narrowly focus on language that I really hope would create an opportunity for acceptance by the chair. As I read this, one of the concerns that many of us had is that the house of cards collapse when you remove one piece the way the legislation is written with all good intention. And I do want to refer to my early remarks. I abhor piracy. And in fact, I see a distinguished former staff member of Chairman Hyde in the room. And we have worked on these issues. So I think it is important to recognize that none of us are against getting away or taking away the bad guys and preserving that wonderful intellectual property. But I think what the gentlelady is offering is that only the property used to actually commit the relevant offenses may be seized or subject to forfeiture. I think that is a thoughtful approach. It goes right to the target. It protects all of those who are using the intellectual property, and I frankly believe this is an amendment we can draw upon. And, Mr. Chairman, I will say this. I see...
Gentlewoman's time has expired.
May I ask an additional 30 seconds, Mr. Chairman?
Without objection, the gentlewoman from California will be recognized for an additional 30 seconds.
I would just like to I'm so glad that Congresswoman Jackson Lee has recognized the former staffer of our former chairman, Congressman Henry Hyde. And I remember the tremendous work that Congressman Hyde did, Chairman Hyde did, to actually put more due process into the seizure situations. And I wish that he were here with us today. The problem was that the Internet wasn't foremost in our mind at that time, and it wasn't anyone's fault. Technology has moved since that time. So I just wanted to thank the gentleman for being here and remember the work of our former chairman. I think if he were here, he would be joining in this amendment. I yield back.
Oh, I was just going to take his name in vain as well. Not in vain, but to say that I'm sure he would support the underlying bill. But in any case, we do appreciate the chairman's former staff member being here today. I'm going to recognize myself in opposition to the amendment. This amendment, the gentleman from Virginia is recognized.
Okay. Well, thank you, Mr. Chairman. I speak in opposition to the amendment. This amendment does not change a provision in the bill. It changes underlying law. The amendment strikes a key part of the civil forfeiture provision contained in Section 2323 of Title 18. Currently, U.S. law permits the government to pursue the seizure of any property used to commit or facilitate the commission of any counterfeiting crime in Sections 23, 18, 19, and 20 of Title 18. The amendment eliminates the term, quote, to facilitate the commission of, end quote, counterfeiting crime from the statute. This amendment would allow criminals to keep the tools they use to steal intellectual property. For example, if a ring of counterfeit labelers with extensive computers, software, and printers were arrested and prosecuted, the government might not be able to seize all the devices used to facilitate the creation of the counterfeit goods. A court could easily determine that the computer that designed the false labels simply facilitated the crime and shield it from forfeiture. This will leave criminals with their infrastructure intact, which allows them to continue their criminal business or sell the infrastructure to the highest bidder. The criminal forfeiture provisions are based upon the civil forfeiture statute. This amendment also, therefore, prevents criminal forfeiture of property used to facilitate a counterfeiting crime. The civil forfeiture provision in Section 2323 already provides extensive due process for anyone who is the owner of property used to commit or facilitate the commission of a crime. Federal law protects owners from improper seizures and creates appropriate procedures to shield confidential or private information. This amendment weakens civil forfeiture laws and weakens our ability to pursue criminals who commit fraud and steal intellectual property. And for all of those reasons, I oppose this amendment and urge my colleagues to join me in doing so. And I yield back.
Mr. Chairman.
The gentleman yields back his time. The gentleman from North Carolina, Mr. Watts, recognized.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, gentlemen. I don't think there's anybody on this committee who would say that historically I've been a big fan of forfeiture. I want to join in welcoming former Chairman Hyde's staff person here. I probably was fighting forfeiture laws as aggressively as anybody because of the due process concerns I had. But I agree with the Chair and the Ranking Member in this case that this is not the forum to start amending the forfeiture law. If we're going to do that, we really ought to have some hearings, which is what my colleagues have been saying all along about every other aspect of this bill. We ought not just back into it as a means of undermining this legislation. I don't think, even if I agreed with this, which I might, if in a different context, if we were dealing with forfeiture law, I don't think this is the place to do it, and so I rise in opposition to the amendment also.
Thank you, Mr. Watt. The gentleman yields back his time. The question is on the amendment. All in favor say aye. Opposed, no. No. Opinion of the Chair, the noes have it. The amendment is not agreed to. We will now go, if the gentleman from Colorado wishes to be recognized, to an amendment that he intends to offer.
I have an amendment at the desk.
The clerk will report the amendment. I believe this is Polis number 8080.
Mm-hmm. That's what I show.
Amendment to the Smith Amendment offered by Mr. Polis of Colorado. Page 26, insert after line 8 the following.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain the amendment.
Thank you, Mr. Chair. As any of my colleagues on the committee might have perhaps seen, Avenue Q, an excellent production on Broadway. One of the signature songs from that is "The Internet is for Porn," and without objection, Mr. Chair, I'd like to submit the lyrics to "The Internet is for Porn" for the record.
Is it printable?
It's printable, and I'm told we're immune from copyright laws, so we can print whatever we like in the record. Is that correct? I'm more scared of copyright laws than anti-pornography laws.
It's under advisement, is all I can.
It has no obscenities.
Without objection.
Thank you, Mr. Chair. And indeed, a high percentage of Internet traffic is porn. A high percentage of piracy is porn. And when we are talking about this bill in its current form, it is truly a pornographer's wet dream. Yes, Mr. Chairman, this bill in its current form would unleash the Attorney General's office to defend pornographers first and foremost. Indeed, about 10 to 15% of Internet searches are for porn. An even higher percentage of traffic is related to porn, and yes, commerce and piracy related to porn. Now, where it is confines with the law, I'm not making the argument that somehow this is an invalid form of commerce. There are, of course, local and state and national laws with regard to consent and exploitation that must be followed, but I would certainly argue that consistent with this bill and the fact that the Attorney General will have selective ability to use their limited resources to go after perpetrators, that in fact pornography and period interest should not be the focus of the Attorney General's protection. In fact, the Attorney General should make sure to protect legitimate businesses before any resources are used to protect pornographers. Under the current language, the Attorney General would use scarce resources to defend the pornography industry. My amendment would simply ensure that American tax dollars are not used to protect the intellectual property rights of pornographic or obscene websites. I have not heard a desire from the advocates of the bill to protect pornographic or obscene websites, and yet that is exactly what the bill would do absent this amendment. Let me be clear. My amendment does not restrict the rights of those who produce that content at all. Under this bill, the Justice Department would clearly be strained, as I questioned the Attorney General last week, with the vast powers that he's given. He would need hundreds of billions of dollars to fully implement this bill. So he will have to be very selective in how to use his resources, and I think guidance from this committee that he should protect pornographers last would be very helpful to the Attorney General in implementing this bill. I think we need to make it clear to the Department of Justice that they should not use their limited resources to defend pornographers, which otherwise would be the consequence of this bill. There is enormous commerce and enormous piracy and copyright infringement with regard to pornography. And frankly, absent this amendment, the Attorney General could certainly have a field day using taxpayer resources to protect pornographers. But I don't think that that was the intent of the committee, and my amendment would clarify that while the Internet may be for porn, the Attorney General's office is not there to use taxpayer resources to defend porn. I urge a yes vote on my amendment. I'll yield to the gentlelady from California.
I have a question, and I'm not sure that your amendment deals with this issue, but I read an article recently about the enforcement efforts of the pornography industry, and the representation in the news article was that it is the most common enforcement action is being taken by the pornography industry, and here's how it would work. They would bring an action against an individual, and actually apparently this has been farmed out to law firms, who will then say you can either pay us $1,000 or we're going to file against you, and it's going to become public knowledge that we're accusing you of accessing pornography, and that most or many of those who are faced with that conundrum, whether or not they have actually accessed pornography, pay up because of the humiliation and embarrassment that would occur by having that become a public allegation. Would your amendment do anything to correct that?
I recognize myself in opposition to the amendment. The gentleman's amendment, intentional or not, would carve out an exemption that makes certain types of content even more widely available online. The absence of effective enforcement encourages more illegal activity, not less. Notwithstanding my personal opposition to the content, we need to respect the discretion of federal law enforcement officials to bring cases they think are appropriate. For that reason, I hope my colleagues will oppose the amendment. Yield back the balance of my time. Are there others who wish to be heard? The gentlewoman from California, Ms. Lofgren.
I move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Going back to the scenario that I had reported just prior to the chairman's statement, and I guess this is a question I'll yield to Mr. Paulos. The enforcement efforts underway that are basically a shakedown of individuals. They have to pay up, or there's going to be a public allegation that they've... Would this do anything to remedy that phenomenon?
I don't believe it would through private actions. However, absent this, it is possible that an attorney general could shake people down for political, ideological, or economic reasons over pornography, much of which is incidentally in violation of the terms of copyright. Much pornography is. We don't have exact statistics, but it's quite likely that the majority of the pornography on the Internet is in violation of a copyright. And this would give the Attorney General and our federal government, which should be scary to many of us, the power to then enforce that against who they choose. But I don't believe it would remedy the private piece.
Now, is the reason why pornography is so ubiquitous on the Internet in terms of infringement? I mean, people have a legal right to create pornographic movies, but I would guess, and I don't know if you know or not, I'll yield if you do, that if you're Mr. Smith, you know, and you've got your credit card, you don't necessarily want that on your credit card that your wife is opening up, and so that you might be led to infringing. Is that the phenomenon?
It is extremely difficult to get good statistics on the pornography industry, and I've read widely different accounts of the size of the industry, both in terms of dollar volume, in terms of the level of copyright infringement. But you're absolutely right. There is, because of the social stigma associated with pornography, additional efforts that many people undertake to be anonymous in that sense, and that, in fact, contributes to the copyright infringement issue with regard to pornography.
Well, I think actually it's important that you've clarified that the amendment would not limit or censor pornography, which is protected by the First Amendment. It would simply mean we're not going to use the taxpayers' money to go after that as a priority in the Department of Justice. I think that makes a lot of sense. I think not to support this amendment. Folks, it's going to be kind of hard to explain back home, and I would yield.
Yeah, and I would go so far as to say that absent this amendment, it's quite possible that the bulk of the Attorney General and Justice's effort would be to protect pornographers from this bill, because that is a large dimension of the copyright issue. And so, again, it's not just a question of a few incidental violators. A substantial amount of the enforcement effort, absent this amendment, would likely be to protect creators of pornography. Again, a legal form, but with limited resources, probably not where we want to focus our efforts on enforcing.
Reclaiming my time, I would ask unanimous consent to put in the record Pink Visual President Allison Vivas to conduct special anti-piracy session at XBIZ-LA that outlines the wide effort being made, informed by copyright experts, to make pornography the top level effort on copyright enforcement.
With that objection.
And I would yield to the gentlelady from Texas.
I'm glad you made that point, and I want to say to Mr. Polis, he's doing very well for a individual securing his law degree from the Judiciary Committee. So let me thank you. As someone who was here when we did many of the legislative initiatives dealing with obscenity and children on the Internet, I want to be very clear that what you are suggesting is let us not use our federal tax dollars to enhance and cover and protect those who are dealing with questions of pornography and obscenity, which, again, the Supreme Court says, I'll know it when I see it. And though the aspects of that dealing with children have been made illegal, some things sneak through. Is that the point? Let us not cover them with all of our resources while they're engaged in pornography and obscenity.
That's correct. It does not affect their ability to create legal content. You mentioned some pornography is illegal. There's other pornography that is fully legal. However, we don't want to make the Attorney General's office an extension of the General Counsel's office at a large pornography company, which this bill would do absent this amendment.
And I feel very comfortable, if you generally continue, I feel very comfortable that you're making no negative statement on the fact of their lack of being covered by the First Amendment, which in many instances we may debate vigorously and abhor. But the point is that their expression is there, but we don't have to use our taxpayer dollars to protect it.
And the gentleman's time has expired.
I thank the gentleman for yielding.
The question is on the amendment. All in favor say aye. Aye. Opposed, no. No. Opinion chair, the noes have it.
I'd ask for a recorded vote, Mr.
Recorded
Chairman.
vote has been requested, and the clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Gallagly votes no. Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes yes. Mr. Pence? Mr. Forbes? Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes yes. Mr. Griffin? Mr. Griffin votes no. Mr. Marino? Mr. Gowdy? Mr. Ross? Mr. Ross votes no. Ms. Adams? Mr. Quayle? Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Conyers votes no. Mr. Berman? Mr. Nadler? Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes yes. Ms. Chu? Mr. Deutsch? No. Mr. Deutsch votes no. Ms. Sanchez? Mr. Polis?
Aye.
Mr. Polis votes aye.
The gentleman from Pennsylvania. Gentleman from
Marino
Virginia.
votes no. Mr. Goodlatte votes no.
Gentleman from Virginia.
Mr. Forbes votes no.
Gentleman from New York. Mr. Nadler.
Mr. Nadler votes no.
The gentleman from Texas, Mr. Gomer.
Mr. Gomert votes yes.
Gentleman from Ohio. That is correct. It's Polis, it's number 16 on the roster. It's Polis number 80. Gentlewoman from California, Ms. Sanchez.
No. Ms. Sanchez votes no.
The gentleman from Ohio.
Mr. Jordan votes yes.
Are there other members who wish to be recorded? The gentleman from Iowa.
Mr. King votes no.
Okay, the clerk will report. Oh, the clerk will suspend. This is Chuck. The gentleman from Arkansas.
Mr. Griffin votes yes.
Clerk will report.
Mr. Chairman, 9 members voted aye, 18 members voted nay.
Majority having voted against the amendment is not agreed to. Are there other amendments? The gentleman from Colorado is recognized.
Again, I have an amendment at the desk, just the order that they're there.
The clerk will report Polis number 202.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Jared Polis of Colorado. Page 20.
Without objection, the amendment will be considered as read, and the gentleman is recognized.
Thank you, Mr. Chair. This deals with the sections relating to the enforcement of orders on page 20, replacing lines 14 through 19. Again, to ensure compliance with orders issued under this section, the Attorney General may bring an action for injunctive relief, and then the language that is replaced is against any entity served under paragraph 1 that knowingly and willfully fails to comply with requirements to compel such an entity to comply with such requirements. We say relief against any entity that knowingly and willfully fails to comply with the requirements of this section to compel them to do it again. I think it's language that improves the overall bill, is consistent with the goal. We also impact on page 22 we eliminate the language from line 1 through 23 regarding the product or services marketed for the circumvention or bypassing of a measure. This, again, applies to anonymizers, Tor, other things that can be used to access sites beyond government censors, the type of product that Ms. Lofgren has mentioned have made possible the Arab Spring, that are critical to maintain free speech here and across the world, and preventing the product from being that is designed or marketed that can be used, even if incidentally, as a tool for infringement of property is not a productive direction. Any technology can be used in good or bad ways. Again, talking about a telephone, you can have a nice conversation with somebody. You can also plot a crime with somebody over a telephone. Tor, a web anonymizer, can be used to learn the true story of Tiananmen Square if you happen to live in China and the government otherwise doesn't allow you to access that story, and in fact only shows happy, smiling people. When you look up the term Tiananmen Square, it allows you to get to the real story. And yes, of course, they have other uses as well, which are less honorable. But what this would do is make it clear that we are not going to be seeking to eliminate products or services designed or marketed that can be used to prevent access to these services. These are, again, typically products that can avoid government censors, that enable the Internet to remain a bastion of free speech. When they are used wrongly, again, the correct answer is to go after the offenders, criminally where possible, civilly where possible, working with other jurisdictions where possible, and working together on a domestic solution that makes sense, unlike the underlying one in the bill. Again, I think with the importance of many of these enabling technologies to free speech, and that's why this bill is opposed not only by ACLU, but by a whole host of human rights organizations that see the danger of actually preventing the incentive and eliminating technologies that allow individuals here and abroad from getting around government or corporate censors. And that's why I offer this amendment, and I hope that the committee will choose to include this in the final bill to ensure that that unintended consequence, because I don't think that was the desire of anybody on this panel, to further potentially restrict speech in those areas that have onerous restrictions. But I think that this provides an opportunity to ensure that, in fact, that is not the case with this bill. And I'll yield back the balance of my time.
Okay, thank you, Mr. Polis, and I'll recognize myself in opposition to the amendment. The gentleman's amendment strikes the inclusion of anti-circumvention devices from the bill. It would allow devices to be developed and distributed in the United States that would circumvent judicial orders to block access to foreign infringing websites. The manager's amendment significantly narrows the scope of this provision. It ensures that only entities that design or market such a product or service for the purpose of circumventing the law can be enjoined. This is an important part of the bill. We work to address technical concerns, but also ensure that we retain strong anti-piracy provisions to protect American jobs, and we want to deter foreign criminals who steal American intellectual property. For these reasons, I oppose the amendment. Yield back the balance of my time. The vote is on the amendment.
Mr. Chairman, I'd move to strike.
The gentleman from California is recognized.
I'd like to, it's very easy, and I think the members are getting tired, and a lot of members have left, just to say no. But I do think that the amendment offered by Mr. Polis is not just an elimination. It's refining the section of the bill. I think that even though it's late and everybody, I'm sure, is tired, we need to have an answer to the human rights question that I raised with my amendment, and that by implication Mr. Polis is raising again with his. There, in fact, whether or not we have this in the bill, likely there will be people create code. I mean, we can't outlaw the creation of code, even if we might want to do so. But to narrow the provision of the bill, as Mr. Polis has suggested, I think strikes a balance that should be supported by all of us. In fact, I don't think we can tell the rest of the world, the individuals who are living in oppressive regimes, that we're going to outlaw the tools that they need to be free people. And if you want to take a look at where's the innovation happening in the world in terms of internet coding, it's still the U.S. I'm not sure that will continue to be the truth if this bill passes. But absent something like Mr. Polis's amendment, we will, and I'm sure it's not the intent, I'm not suggesting it is the intent, but the result will be further oppression of individuals in repressive regimes. That's just a foregone conclusion. So I would urge the chairman to rethink his opposition to this narrowly drawn amendment for the sake of those who are living in regimes that care so little about human rights. And with that, I would yield to the gentlelady from Texas.
I'd like to add to that comment, and specifically, I thank the gentlelady for yielding. I hold in my hand a letter dated from the Secretary of State to the chairman of the ranking member of the Foreign Affairs Committee, dated October 25th, that specifically speaks to the Arab Spring and indicated that the State Department in particular was committed to advancing both Internet freedom and the protection and enforcement of intellectual property. We must hold governments accountable to the international commitments and obligations they have taken with respect to freedom of expression, which apply equally to online activity. Given the volume of communication over the Internet today, we have focused our efforts on ensuring that the Internet is a medium through which people can safely and effectively express their opinions. In this letter, as we have been saying throughout the debate, there should be no exclusivity on the protection against piracy and the freedom of expression in the First Amendment, which I think the gentleman's amendment goes to. The letter goes on to say the Arab Spring shows that the promise of the Internet as a medium by which peaceful demonstrators can mobilize citizens in the face of government oppression is valuable. And the Internet also offers tremendous opportunity for creators and inventors, but that promise will not be met unless the rules of copyright and trademark are protected and enforced, which we are all saying. They go hand in hand. The rule of law is essential to both Internet freedom and protection of intellectual property rights. I think that is what the gentleman's amendment captures, and this is a letter that I ask unanimous consent to submit into the record from the Secretary of State that understands what we are saying. Internet freedom and protection of intellectual property.
Without objection, the letter will be
I would
part
yield
of the record.
the balance of my time to Mr.
Thank you.
Collins.
And in determining whether we need a vote on this one, I believe the chairman specified that he would work with Ms. Lofgren on this related issue. So I'm not wedded to my language. And again, I just wanted to reiterate, I believe the chairman expressed that he would be working with Ms. Lofgren on this issue of making sure that there is global free speech. Is that correct, Mr. Chairman?
I don't know, sir.
Okay. I'm sorry, would the gentleman repeat the last?
Okay, I believe in a previous discussion with
Yes.
Ms. Lofgren, you expressed a desire to work towards resolving this. I am not wedded to this particular language. I again just wanted to reiterate that that was a discussion.
If the gentleman is interested in knowing whether we'll work with him, of course we will. I just can't make any guarantees.
Right. Right. Again, I think Ms. Lofgren mentioned there might potentially be later an amendment if we can't figure this out, but we would like to work with you, and I'm happy to withdraw the amendment.
Okay. I appreciate the gentleman withdrawing it. We'll work on it between now and tomorrow, and the gentleman will be recognized to offer the amendment again if we don't work it out. Okay. We will now, the gentleman from Wisconsin is not present right now, so we will go to the gentlewoman from California if she wants to offer.
Mr. Chairman, could I ask a question, please, procedurally?
Yes.
You mentioned tomorrow, and we have some dim hope that it will be here. Could we just ask in terms of planning our night, what was your intention?
I've been asked two frequent questions, how late we're going tonight and whether dinner is going to be provided. And the answer is late and yes. And I'll welcome the gentleman to come over to the offices on the majority side. He is welcome to partake of 3 different kinds of pizza.
Health food.
We provided pizza for your side, I understand as well, but you're still welcome to come over.
I appreciate that.
Mr. Chairman.
Mr. Watt has discovered it
Mr. Chairman.
The gentleman from New York, yes.
Are you providing 3 types of pizza for the minority, too?
Yes. The answer is yes.
I appreciate the chairman's even-handedness.
Uh-oh, we're in trouble. Mr. Watt reports 4 different kinds. We may have made a mistake there. The gentlewoman from California wish to offer an amendment?
Yes, I do, Mr. Chairman. The amendment's at the desk. It's 19 on the roster, Lofgren 58.
And the clerk will report Lofgren number 58.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Ms. So Lofgren of California. Page 25, strike line 13 and all that follows through page 28, line 5, and insert the following. 1. Internet site dedicated to the theft of U.S. property. A. In general, an Internet site is an Internet site dedicated to the theft of U.S. property if it is a U.S.-directed site that has only limited purpose or use other than, and whose owner or operator uses the site willfully and primarily to 1. Infringe copyright under Section 501 of Title 17 United States Code. 2. Violate Section 1201 of Title 17 United States Code. Or 3. Use counterfeit marks in a manner that violates Section 34D of the Lanham Act. 15 U.S. Code 1116D. B. Exclusions.
With that objection, the amendment is considered as read, and the gentlewoman from California is recognized to explain the amendment.
Here's what the amendment does. It replaces the existing definition which would allow lawsuits under the new private right of action created in this legislation. Under this amendment, a website could be sued and cut off from payment and advertising networks if it is operated primarily and willfully to engage in acts that violate copyright and trademark laws. Now, if a website is consistently taking down infringing contents in response to complaints by right holders, it should not be condemned as dedicated to the theft of U.S. property. As a basic principle, this bill is about remedies. It should not expand the existing boundaries of liability for copyright or trademark infringement. But this could be the result of the definition in the manager's amendment dedicated to the theft of U.S. property. Specifically, a foreign website could be sued by a private party under Section 103 for taking anywhere on its site affirmative steps to foster a violation of copyright or trademark law by other persons. Now, instead of limiting private lawsuits only to infringement and violations of law actually committed by the websites, the manager's amendment leaves the door open to aggressive theories of secondary liability. For example, a court might find that a website, quote, took affirmative steps to foster, unquote, infringement, and therefore be subject to mandatory termination by payment and advertising networks, even if there was no copyright or trademark violation, even if there was no infringement. Designating an entire foreign website as dedicated to theft of U.S. property and terminating all commercial links to the United States is a very aggressive remedy. It should be limited to criminal websites whose violations of the law are unambiguous. This definition will capture all the major rogue foreign websites that the authors say that they are after. The amendment will make clear that innocent actions will not be the subject of this draconian enforcement scheme. You know, the DMCA, although it's been sometimes criticized, has worked oftentimes. The existing language would sweep IP sites into its scope. Websites where people are living up to all their obligations under the DMCA, including registering a copyright agent, doing notice and takedown, and terminating repeat infringers. This is what really we should be encouraging for foreign sites, not discouraging. The reasons that sites comply with the DMCA that might still be swept up is that the safe harbors are limitations on liability, not affirmative defenses, and as a result, you can be completely compliant with the DMCA, and yet a qualifying plaintiff could argue that you are nevertheless still technically violating Section 501 of the Copyright Act, even though everything you are doing is perfectly legitimate. You know, I think that the amendment also removes the redundant recapitulation of the inducement standard that is in the manager's amendment, and including that in this definition of site dedicated to theft is redundant and will possibly confuse the courts, leading them to ask what more Congress must have meant than the inducement already included in subsection 1AI. I think the amendment is particularly important because Section 103 includes a private right of action, and getting the definition narrowly and correctly drawn is crucial to defer trial lawyers from seeking, and I'm not opposed to trial lawyers. I am a member of the Trial Lawyers Association, but we do know that gotcha lawsuits are not about stopping piracy, but about harassing legitimate sites. And we have seen that, as I mentioned earlier in the discussion with Mr. Paulus, the shakedown that occurs in some enforcement actions. And to think that the shakedown will not occur simply because the remedy is payment cutoff is to misunderstand the nature of the remedy. I think that it's one thing to say we're going to trust the Attorney General to always bring the right matters, but we're opening this up to anybody who wants to bring an action. And if we don't have a narrowly defined definition in the Act, we're going to see abuse, as we have sometimes seen under existing law. So I think this amendment not only should be supported, I think it's essential. And I see that my time has expired, so I yield back, Mr. Chairman.
I thank the gentlewoman.
Mr. Chairman.
The gentleman will suspend. I'm going to recognize myself.
Well, certainly, Mr. Chairman.
Thank you.
You're in the seat.
Thank you, Mr. Chairman. The gentlewoman's amendment seeks to significantly narrow the definition of an Internet site dedicated to theft of U.S. property and makes the bill less effective. Most in Congress want to seek meaningful solutions to stem the economic harm created by foreign rogue websites. As we developed the manager's amendment and drafted the bill, we heard from individuals, small businesses, and various stakeholders representing different industry sectors. We worked to address technical concerns, but also to ensure that we retain strong anti-piracy provisions to protect American jobs and go after foreign criminals who steal American intellectual property. By requiring proof that an operator willfully intended to violate an intellectual property right, the amendment would require an intellectual property owner to prove the state of mind of a defendant who they likely cannot reach because they're in China or Russia or some other foreign location. In addition, the exclusions in the amendment protect pirate sites that adopt a notice and takedown policy despite the fact that the site is still engaged in intellectual property theft. So for these reasons, I oppose the amendment.
Mr. Chairman.
I will recognize the gentleman from Colorado.
Move to strike the last word.
The gentleman is recognized.
Thank you. When we're talking about the site violating copyright and infringing and taking down the site, 99% of the time what we're going to be talking about here is user-generated content. Could be 95% of the time, 99.5%, whatever, the vast majority of the time. There is a difference when it is an offending site, in which case the proprietors of the site are engaged in a willful act of copyright infringement, versus creators of an enabling technology or implementers of an enabling technology, as simple as an electronic bulletin board, which beyond their own control might incidentally be used by some of its users for illegal purposes. Again, all of these platforms that I've seen that have been created have legitimate functions, have legal uses. There is no doubt that like any technology, like the telephone and indeed like an automobile, which you can illegally drive into a building if you so choose, or illegally run over a pedestrian if you so choose, so too these technologies can be used for illegal purposes. This amendment is important. Because what it essentially does is make sure that we are not going after sites that might only have user-generated content that infringes upon the theft of U.S. property. This is a very draconian solution that in the arsenal for the Attorney General should only have very specific incidences under which it can be used. I think Ms. Lofgren spells those out effectively. In addition to the danger of wrongfully disabling sites that have user-generated content that may be infringing, the precedence that this site sets among global nation-states and others is a very negative one. Again, by stating this ourselves with regard to foreign-operated sites, we are effectively encouraging a country-by-country regime and treatment of foreign sites to them, which are domestic sites to us, which would harm the growth of legitimate companies and legitimate technologies, no doubt all of which have uses, or most of which have uses, which are illegal. Something as simple as email, something as simple as Facebook, something as simple as a video platform like YouTube. These can all be used in ways that are contrary to the law, and the individuals responsible for that should be held fully accountable under the law. The answer, however, should not be to disable those sites. And just as we are seeking to do this with foreign sites, there is nothing to stop this precedence going forward to have other countries disabling our own sites. Sites like YouTube and Facebook that employ tens of thousands of Americans and many others, because we, the shining light of freedom of speech and of intellectual property enforcement, have gone down this path and set this precedent. A very dangerous precedence for us to set, and one that will ultimately be counterproductive. And I think it's critical, again, to realize that user-generated content from which most of these infringements are derived, while they might be enabled by a technology that also enables legitimate commerce and communications, are not the fault of the technological enabler that creates it. No more than Ford should be held liable for somebody who drives into a building or kills a pedestrian, and no more than a gun company should be liable for a gun that is used in a murder. Happy to
Would the gentleman yield?
I'll be happy to yield.
Please hold that thought about the gun company not being held liable. I think the gentleman's hit on an extremely important point, and I would just like to comment on the gentleman from Virginia, the chair. I think he has somewhat misunderstood the likely practical ramifications. This bill will face one of two types of foreign entities. The type that doesn't answer the claim and gets a default judgment, in which case it's really just a prove-up, a prove-up without a defense. The other is a foreign entity who is willing to come in and fight in court. And if you're willing to come in and fight in court, why shouldn't you have all reasonable defenses, including that one? So I know that the gentleman meant well when he said, well, this wouldn't work. But the practical reality is the sites we're talking about are not going to, for the most part, they're not going to defend. They're going to be default judgments. And the few who come forward, why wouldn't we have them say, look, I have all these legitimate items and so on? Additionally, well, I think I've made my point. I'll seek other time. I yield back to the gentleman.
Yeah, and I'll be seeking some additional time as well. Hopefully somebody will call some.
Does the chair have a question, I guess?
Would you mind?
The question occurs on the amendment offered by the gentleman from gentleman.
Mr. Chairman, I object. I had sought time.
Oh, okay.
On my own.
Fine. The chair recognizes the gentleman from California for 5
the gentleman yield.
I certainly will yield.
Thank you.
Gentleman.
Thank you. I thank the gentleman. Again, if I'm getting this correctly, the Digital Millennium Copyrights Act, unlike this bill that's kind of going through quickly with only some of the stakeholders at the table, was a result of a long process, and it's worked. It's relatively worked. This applies that same concept of you are responsible for a takedown to the foreign infringers. It sounds like a reasonable, very reasonable standard to hold foreign infringers to. We hold domestic infringers to. Let's equate the two standards. It fundamentally works for the Internet, works for rights holders. I'm happy to yield back to the gentleman from California.
I thank the gentleman. Hopefully the chair would have some reasonable response to why this level of common sense prove-up doesn't make sense. It appears as though the idea that a materially non-infringing use is somehow not a good defense and should not be included explicitly in the bill begs me to say, please, Mr. Chair, can you tell me why that shouldn't be a defense? I'd be glad to yield to the chair.
I would simply say to the gentleman that under criminal law, criminal copyright law, willfully is a very high standard to prove, and I don't see the need to provide that standard here with regard to foreign infringers of copyright.
Well, let me understand this for a moment. You don't want to give rights to foreign infringers, but you don't want to...
They have rights to come in and defend themselves in the case. The question is, how high a threshold does the U.S. prosecutor have to reach in order to make their case?
I think if I'm correct, this is the private right. This is in fact the plaintiff's trial bar, a group that at least on this side of the aisle, we tend to say, wait a second, we don't want to give them the easy road to collect monies and to do their actions. So I'm trying to understand why you would have a low standard for that. Additionally,
it's not a low standard. It's just not the very high standard.
It's a pretty low threshold. I'd yield to the gentlelady from California.
The question is, and if I'm hearing the chairman correctly, that non-willful infringement should be the cause of action here. Is that your intention?
I think that's what I heard.
Probable cause in the Section 102 action.
So the standard under U.S. copyright law would be preponderance of the evidence, not willfully. I mean, why would we make it harder for U.S. entities trying to protect intellectual property rights?
We're claiming my time, Mr. Chairman, and not to be offensive, but you already voted down the idea that we'd limit this to U.S. entities. This ain't U.S. entities. It's anybody who wants to come play in our playground. I'd yield to the gentlelady from California.
I think the chairman is confusing intent with the evidentiary standard. They're different. And what I'm hearing him say is that we could have this action would lie even when there wasn't a willful infringement. I think that's a problem. And as I've mentioned, you could end up with a private party taking action based on the affirmative steps to foster when all was said and done, there was no violation, no infringement as the statute is currently crafted. That can't be what our intention is. And I thank the gentleman from California for yielding.
I thank the gentlelady with the
I
would be glad to yield again to the gentleman.
So the gentleman now is complaining that we've taken domestic sites out of the legislation because we took them out because there are other copyright laws and standards for enforcement of those laws which have a lower standard for proving copyright violations than is called for in this amendment for foreign sites. That's why I oppose the amendment. You're asking for too high a standard. I don't understand why we would have a higher standard to prove copyright infringement with foreign sites than with U.S. sites.
Well, I appreciate that, but this is a rush on the court question as much as anything. Having a high standard for domestic people to bring this in the courts to seek a remedy against a foreign entity, understanding, again, I repeat, as a practical matter, as somebody who has defended intellectual property, my own, repeatedly around the world, the fact is the bad guys aren't going to come up at all. You're going to generally get a default judgment, and there your prove-up, even at this high standard, is just to show a pattern. But, Mr. Chairman, if you can't take this one, then once again what we're seeing, and this is a pattern, is there was no interest in compromise. This has been a take it or leave it sort of approach, and I'm frustrated because that's not the history of this committee. This is a committee that generally comes in and takes good amendments and even offers secondary amendments if they weren't crafted well enough. Haven't seen that today. I yield back.
Question occurs on the amendment offered by the gentlewoman from California. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it.
I ask for a recorded vote, Mr. Chairman.
Recorded vote is requested. The clerk will call the roll.
Mr. Smith? No. Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Lundgren?
We're making progress?
Mr. Shabbat?
What was this one? Was this ICE?
Mr. Issa? Yes. Mr. Issa votes yes. Mr. Pence? Mr. Forbes? Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan?
Is Chip still going to offer this?
Mr. Poe? Mr. Poe votes no. Mr. Chiefitz? Mr. Chiefitz votes aye. Mr. Griffin? Mr. Griffin votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? Mr. Ross votes no. Ms. Adams? Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Conyers votes no. Mr. Berman? Mr. Nadler? Mr. Nadler votes no. Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes yes. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes yes. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Ms. Sanchez votes yes. Mr. Polis?
Aye.
Mr. Polis votes aye.
Gentleman from Virginia, Mr. Forbes.
Mr. Forbes votes no.
Gentleman from Ohio.
Mr.
Gentleman
Chapman
from
votes
California, Mr. Lundgren.
no. Mr. Lundgren votes no.
Gentleman from Ohio.
Mr. Jordan votes no.
Gentleman from Arizona.
Mr. Franks votes no.
Are there other members who wish to be recorded on this amendment? The gentleman from California, Mr. Berman.
Mr. Berman votes no.
Clerk will report.
Mr. Chairman, 7 members voted aye, 24 members voted nay.
Majority having voted against the amendment is not agreed to. Are there other amendments? The gentleman from Ohio, Mr. Shabbat, is he prepared to offer an amendment?
I have an amendment at the desk, Mr.
The
Chairman.
clerk will report amendment number
22. 22.
22 or 13, whichever number it is.
Amendment to the amendment in the nature of a substitute to H.R. 3261 offered by Mr. Shabbat of Ohio. Page 35, line 16.
Mr. Chairman, I ask
Without
unanimous
objection, the
consent.
amendment will be considered as read, and the gentleman is recognized to explain the amendment.
Thank you, Mr. Chairman. I'll be brief. This amendment simply provides that service will be proper when it is served on an agent designated by a corporation to receive service of process. The purpose of the amendment is to ensure that one of the ways in which non-infringing third parties may receive copies of court orders is through well-established legal channels for serving corporations. This amendment will ensure that a copy of the court order, which is what triggers the requirement for an entity to act, gets into the hands of the right people at the entities that are going to be required to take actions to shut down an infringing site. This makes it clearer to the parties involved excuse me, than stating that service is permissible in any place where an entity or representative of that entity may be found. For example, this eliminates the situation where a copy of an order is handed to a company representative who's delivering a speech at a conference, for example. I yield back.
Chairman.
Will the gentleman from Ohio yield?
I'd be happy to yield.
I thank the gentleman for offering this amendment, which I think improves the underlying legislation, and I support it, and I'll yield. The gentleman from Ohio, if you will yield, and the gentleman from Virginia.
You just got to know how to operate.
If the gentleman yield, I too support his amendment. He's 2 for 2.
Thank you.
Higher percentage than
Better
anyone
shut
else.
it down there.
Are there other members who wish to be heard on the amendment?
Yeah, Mr. Gentleman yield.
The gentlewoman from Texas, Ms. Jackson-Lee, is
Yeah,
recognized.
Mr. Chap, let me just inquire. Your explanation again is to avoid false service or service to, if you will, secondary representatives. Can you just, you gave the example of the speech and someone being given service.
Reclaiming my time. In other words, if you have a corporation, they usually have a certain place they have to be served. They have an agent. It's just making it clear you serve the agent where the corporation is designated for service.
Thank the gentleman for yielding. I return back
Anybody
whatever time I have.
Okay, if no one else requests time, I'll yield back.
The question is on the amendment. All in favor say aye. Aye. And opposed, nay. The amendment is agreed to. Are there other amendments?
Mr. Chairman, I'm not sure if I'm going to be up next, my 103 amendment.
I'm looking to see if there are other members who were listed as having amendments before you.
From what I can tell, I'm next in order, but it'd be
I'm sorry, is this the ISA number 76?
Yes, sir.
Yes. The gentleman is recognized for the purpose of offering an amendment.
Thank you. This clerk will designate.
Why did I think the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Mr. Issa.
Without objection, the amendment will be considered as read. The gentleman from California is recognized to
Thank you, Mr. Chairman. This is somewhat similar to the last amendment that fared well but not well enough. The difference here is we are in the business of protecting U.S. copyrights. It's pretty much that simple. So it requires that the person must be both a U.S. copyright or trademark holder and a U.S. person in 103. Now, again, I beg everyone here to understand this is the private cause of action. So if I can emphasize enough, you're going to sue in U.S. courts. You're going after U.S. persons. You're making a claim. All we're saying, similar to my Open Act, is why in the world wouldn't you be expected to be a U.S. entity with the U.S. copyright? If you are not, then what you're doing is you're suing one direction. You're coming into this process potentially with absolutely no downside. You make a frivolous claim. You make maybe 1 million frivolous claims. You maybe collect some money.
Would the gentleman yield?
I will in just a second. Practically an Internet scam, and you're not vulnerable to anything because you've got no assets here. So, again, it is not an unreasonable. It's expected. Mr. Nadler, I yield.
Yeah, I really don't understand your amendment. You're saying that in order to bring the suit, you have to be a U.S. citizen and the copyright owner?
No, a U.S. person, which would include a U.S. corporation with the copyright.
In order to bring the suit against an alleged infringer?
That's correct. You'd have to have a U.S. presence in order to come into the U.S.
U.S. person meaning someone who's present in the U.S.?
Well, no. We use the term specifically. A U.S. corporation would comply. So if you happen to be a U.S. person.
Let me ask you this. What are you trying to prevent?
I'm trying to prevent false claims by entities having, you can be a Nigerian-based sham entity, and if we don't have some protection as to who has a right of action,
in a U.S. court?
Yeah, in a U.S. court. And also all we're doing is saying, well, why in the world, when you're going to spend U.S. taxpayers' money to enforce copyrights, that you say, look, it's going to be a U.S. copyright in a U.S. entity.
So you're saying that Nigerian...
I use Nigeria because they're famous for a certain kind of spam.
Whoever. A Nigerian plaintiff who is alleging a copyright infringement in the United States?
Yes.
Should not be able to come into a U.S. court?
With a non-U.S. copyright and without an entity here that holds it. That's correct.
Well, if we did that, wouldn't
and going after a foreign site, think about this.
But wait a minute, if we did that, wouldn't that lead to foreign non-enforcement of our copyrights?
No, understand. The way this thing, if you leave this out, you open yourself up to, for example, a foreign entity coming into our courts to enforce against another foreign entity and then having our U.S. companies act on behalf, all of which is done at our expense.
Against another U.S., against the foreign, not against the U.S. entity.
Right. This is about foreign entity primarily is the claim of this bill. So,
and therefore, in other words, none of this touches the United States, and therefore it does not open us up to retaliation against enforcement of our copyrights abroad?
Well, yes, that's correct. And that's all we're really looking at is that we've said all along that if this is to become law, let's at least make sure that what we're doing is going after the bad guys on behalf of U.S. entities and U.S. copyrights. It seems so simple that you wonder why it's necessary. If someone wants to show me where it's in the bill and explicit and taken care of, I wouldn't be making this. But we asked and we could not get it. And so we said, well, wait a second here. This is U.S. taxpayer dollars in support of an action that's likely to mandate, with the Justice Department's assistance,
all kinds of enforcement, and we're looking and saying before we spend the money, either in the 102 or the 103 portion, this is the 103, let's just make sure that we've got a U.S. presence. That's all we're trying to do with this, and that's the reason that we are bringing it up, and then now we're bringing it up in the private cause of action because we think it has an even better chance of being accepted by the chair. And I yield back.
Mr. Chairman.
The gentleman from Virginia, Mr. Goodland.
Mr. Chairman, this is not at all dissimilar to the amendment the gentleman offered earlier. If you want to think about it, the United States is by far the world leader in intellectual property. We sell it in virtually every country in the world. Copyrighted materials, goods that are trademarked with U.S. trademarks, and so on. So the precedent here that you'd be worried about setting would be that if you went to some other country in the world and said, if they have a law that attempts to enforce their copyright owners' protections in other countries, and you say, well, our goods are being sold in your country too, we want you to protect our goods against foreign sites that are getting into that country's consumers and selling stolen goods. We set the precedent here by saying, well, the United States isn't going to allow that in our country, so why would they allow it in some other country around the world? It's also counter to commitments that the United States has made under existing trade agreements. So it creates a terrible international precedent, and I would strongly oppose it.
Would the gentleman yield?
I would yield.
I appreciate that. I've spent years on the Foreign Affairs Committee, and I'm trying to, although not the Ways and Means, I'm trying to understand what country would allow a foreigner, let's just say an American, to come into their country and expect them to spend their money against another foreign country's company at their expense without that entity being in some way domestic. If you turn it around, they would laugh at us if we said that they would retaliate. No country is going to enforce against another country's company and then secondary against their own people without a presence and a right.
Well, sure they would. If you got a foreign entity selling goods into a country that are counterfeit, fraudulent, maybe harmful to the citizens of that country, and they're manufactured by a company in that country, they're going to take the same position the United States takes on that. Why wouldn't they be concerned about those goods coming into that country if they're goods that belong to somebody else?
If the gentleman would,
and says that they want to have that protection in that country.
If the gentleman would yield.
Sure.
I would see your point, except in this case, this is the private right of action section of 103. So what we're really saying is, I get to come in and I get to sue another foreign entity, but my real purpose is not to sue the foreign entity and foreign from that country. My real reason is, in fact, to get enforcement and perhaps not perhaps, but definitely money damages against entities downstream. So I can actually come in and make an allegation against an eBay delivery from the United States into China, and then turn around and get the Chinese government to, in fact, go after U.S. entities that are operating in China. That means it's the
reclaim my time. The gentleman just noted that this is, unlike the gentleman's first amendment, which involved the governmental action, this is the private right of action that the gentleman's talking about now. And U.S. entities go into other countries' courts all the time, seeking protection of their intellectual property rights, and they want to avail themselves of whatever remedies are available in those countries. Different countries have different remedies available to them, so I don't understand why the United States, which certainly invites people to do business here from all over the world, why we would deny access to our courts to them when we expect to have access to their courts in their country.
Well, if you'd yield one more time, because it's a reasonable level of standing in order to operate in this case. Again, as I said before, you set up a U.S. corporation, you put your U.S. trademark in it, and you've met the requirement. We're not looking at an onerous standard, but we are saying whether it's a private right of action or the Department of Justice spending your taxpayer dollars, we think that those priorities should go to the entities, and it's not even a difficult standard to reach that we're trying to put into the bill.
It may not be a difficult standard, but it's an unwise one, and therefore I oppose the amendment and yield back to
the gentleman's time has expired.
Mr. Chairman?
The gentleman from North Carolina, Mr. Watts, recognized.
Mr. Chairman, I rise in opposition to the amendment.
The gentleman is recognized for 5 minutes.
this is another one of those amendments that I think is just counterproductive and beyond the pale.
Would the gentleman yield? What would beyond the pale mean? Are you saying that somehow I'm disingenuous in my my statement here?
If I thought you were disingenuous, Mr. Ice, I would say that. I said it's beyond the pale of my understanding. The rationale for it, you know, then you try to take down my words. But you know,
no, I want to take down your meaning. What is it you meant by beyond the pale? I'm trying to understand. We just had a colloquy on this.
Right. It's okay. All right. Let me, if you let me get more than a half a sentence out, maybe you would understand. You obviously not accustomed to listening very much. You like to talk. You don't like to listen. And the difference here, the First Amendment, was you were talking about U.S. government money, attorneys, attorney general. This is private rights of action. And we have individuals throughout the world who have property rights, intellectual property rights. And you are saying, you're inviting other people throughout, other countries throughout the world not to allow those individuals to exercise their property rights in those countries. And additionally, the way this is written, because you would require them to hold a person who, a United States person who holds a copyright registered under Section 408 of Title 17 of the United States Code, you are also excluding a bunch of people who you're making them have to cater to U.S. law. So I mean, this is I understand your desire to draw this out, but I just don't understand why you, of all people, doing business around the world, having done business around the world, would be trying to cut off the rights of individual citizens in the United States to enforce their copyrights in other countries.
Would the gentleman yield?
That's exactly where this will lead us to. Yeah, I'll yield to the gentleman.
Would you just said I'd wanted to cut off the rights of U.S. citizens. This is actually defining no limitation on U.S. persons or U.S. corporations.
But you're inviting retaliation by doing this. That's the point that I think everybody in here is trying to get you to understand. You're inviting other countries to apply this standard, which is an unfair standard that we would apply. You're inviting other countries to apply it in their country.
Would the gentleman yield?
It's his time.
I'm happy to yield to the gentlelady.
Here's why I think...
Maybe she can explain why...
Here's why I think the point you're making is mistaken. It assumes that this remedy is available anywhere else in the world, and it isn't. Well, it's not available in China. It's not available
reclaiming
in Europe.
my time, there are a number of remedies that are available in the United States that we are trying to get other countries to harmonize their intellectual property. I mean, there are a bunch of things that go on in the rest of the world. So the implication here is we should be rushing to the bottom rather than setting a high standard ourselves and encouraging other countries to rise to that standard. And I don't accept that. I'll yield back to the gentleman.
Well, I think we are rushing to the bottom with this scheme to take down domain names. But and I'll get my
this amendment now. So I'm yielding to you for that purpose.
And I'll get my own time to go further. But the point is, this is an extraordinary remedy that we are giving to individual plaintiffs to do something that no other country in the world permits.
Reclaiming my time. We would like for other countries I would like for other countries to rise to this standard. Perhaps we would have intellectual property protected around the world as we're trying to protect it in our country. I'm not arguing that any other country has it, but if we do this and we set the standard, you can be absolutely assured that no other country will ever have it. And that's, so I'll yield back.
The gentleman's time has expired.
Mr. Chairman?
The gentlewoman from California, Ms. Lofgren, is recognized.
I'd like to move to strike the last word.
Gentlewoman is recognized for 5 minutes.
Obviously, we have a disagreement here, but I'd like to explain why I think this is a good amendment and why it would be a mistake not to adopt it. This is far from a frivolous amendment. In fact, I was very concerned about the negotiations over ACTA that were done in secret by the administration as a treaty matter that was never going to be brought to a treaty, to the point where I actually asked and required the U.S. Trade Representative to come in and brief me. They did it. I can't talk about it because it was a classified briefing, although I can say I have no idea why it was classified. But I'll just cut to the chase and say this. Specifically, we did not ask other countries to go into an Internet monitoring system. We specifically did not ask them to go into a domain name takedown system. And I think if we were to do that, we would end up with the kind of balkanized Internet that I discussed at the very beginning of this markup. It is not only not going to help copyright owners, it's going to do significant damage to one of the most innovative sections of the economy and also a facilitator of creativity and free speech. That's what I believe will happen if this scheme were to be adopted throughout the United States. But getting back to Mr. Ice's amendment, we are going to have, I would suspect if this ever becomes law, there will be a substantial number of I don't want to say frivolous because that is pejorative, but there will be a multiplicity of private causes of action that occur, even within our own U.S. persons. To open up to the world the ability to come in and basically abuse our system and shake down our people is not something that I think we ought to countenance.
Would the gentlewoman yield?
In just 1 second. I think that although Mr. Ice's amendment, at first blush, would seem to invite the kind of concerns that have been expressed. In fact, it will do the opposite, and it will, hopefully this bill will not become law as crafted. But I think Mr. Ice's amendment is an important one. I would be happy to yield to Mr. Johnson.
Thank you. This amendment would require that a person be both a U.S. copyright or trademark holder and a U.S. person to file under Section 103. So that does appear to have kind of like an exclusive qualification. You got to be American or have a
would the gentlelady yield?
And so what I'm arguing is this, Mr. Ice, yours and Ms. Lofgren's legislation would purport to recognize the global nature of this problem and set up a mechanism to deal with it, and anticipating multilateral discussions about that. And I think that is a step in the right direction, but that seems inconsistent with this amendment.
If a gentlelady would yield.
Let me recall my time, and then I will certainly yield. Well, let me yield to Mr. Ice to describe.
First of all, the amendment would allow anyone to take their copyright, put it inside a U.S. corporation, and be fully qualified. So it's not about a U.S. citizen or green card holder. It's not nearly that narrow. But let me just be illustrative of one thing simple. The Open Act is different. That's true. But the Open Act goes to the ITC. To have standing in the International Trade Commission, you have to be an American entity because it exists under the trade laws to protect American entities, and it is well proven, and it has been around a long time. So when you really look at the problem with this bill that I've been trying to get through people's heads all day, including with amendments, is we have tested trade bills, laws that work very well. The ITC deals constantly with patent infringement, with things coming in where foreign entities are doing something and hurting an American manufacturer, and they exist for that reason and have existed for a very long time. And they do require American entity.
Reclaiming my time, I would just close by saying that not only is the world not moving in this direction, but Europe specifically took a step to preclude this as a remedy, and I think it is to strategically establish themselves as more competitive than the U.S. in anticipation of this bill.
Question is on the amendment. All in favor say aye. Opposed, no. No. The noes have it, and the amendment is not agreed to.
Mr. Chairman?
The gentleman from California.
At this time, I would move to adjourn until time certain tomorrow, or to recess until time certain tomorrow.
Is that debatable?
No.
Okay.
It's highly privileged.
That is a privileged motion, not debatable, so we will vote immediately on whether or not to recess until a time certain.
Mr. Chairman, do I have to name the time tomorrow, if that's the case?
The question to adjourn. The question is on the motion.
The question is on the motion to adjourn. All in favor say aye.
Aye. Opposed,
no. No. Noes have it. The motion
Mr. Chairman,
is agreed to.
I do not ask for a recorded vote on that.
I thank the gentleman. We will continue with our amendments, and before I recognize the gentleman from Arizona, Mr. Quayle, does the gentleman from Utah want to be recognized? Or is the gentleman agreeable to going to the amendment offered by Mr. Quayle?
Mr. Chairman, what I would love to do, yes, go to Mr. Quayle's first. Yes.
The gentleman from Arizona, Mr. Quayle, is recognized.
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261.
Without objection, the amendment will be considered as read. The gentleman is recognized. Explain the amendment.
Thank you, Mr. Chairman. And, Mr. Chairman, I actually have an amendment down the roster that I am withdrawing. Even though I believe it is good policy, I do not think that this is the proper vehicle for that discussion, and so I will be withdrawing that amendment. But I believe that this amendment is something that is necessary, is something that will improve the substitute amendment, which I support. And the amendment merely states that any qualifying plaintiff, if the court determines that any qualifying plaintiff knowingly misrepresented that an Internet site is an Internet site dedicated to theft of U.S. property, then the court shall order that the qualifying plaintiff has to pay reasonable attorney fees and court costs to the defendant. Mr. Chairman, I believe that this is a necessary amendment because one of the concerns people have is that small startup foreign Internet sites might become targets for larger content providers. The intent of the underlying bill and the intent of the bill is to go after sites that are dedicated towards piracy and distribution of copyrighted material. And I believe that this actual amendment will make it so that some of those fears will be alleviated. And I also do believe that it will reduce the amount of litigation that could come out of this, because both the plaintiff will have to make sure that they are making the right determination that the site that they are going to bring to court and bring a court action against is actually a site that is dedicated to the theft of U.S. property. I understand that what we do in Congress has a lot of unintended consequences, and I do not want this bill to be improperly used as a blunt instrument to go after sites that really don't fall under the sites that are dedicated to stealing U.S. property. So I think that this would be a proper amendment to put in so that if a court finds that the plaintiff knowingly misrepresented that the Internet site that they brought to court was not an Internet site that is dedicated to stolen U.S. property, then they will be liable for court fees and reasonable attorney fees. So I believe that this is a good amendment. It is something that should be passed, and I urge my colleagues to...
Would the gentleman yield?
I will be happy to yield, Mr. Chairman.
Thank the gentleman for offering the amendment. I agree with what he said about the amendment and urge my colleagues to support it as well. And the gentleman yields back his time. Are there other members who wish to be heard? The gentleman from Colorado, Mr. Polis.
Thank you, Mr. Chairman. I agree this is a good amendment. It has a very, very narrow and difficult standard for the attorney fees to actually have to be paid. It has to be knowingly misrepresented, seldom invoked. A good amendment, but hardly one that repairs a damaged bill. And I'm happy to support the amendment. And I yield to the gentlelady from California.
I would note that, as discussed earlier and the other amendments offered, you can run afoul of the bill if you don't infringe, if you don't willfully take an action to infringe, and yet this standard is a willful one. So I support it, but I think that what's good for the goose should be good for the gander. I mean, if you can inadvertently run afoul of this and end up being at the bottom of a lawsuit, you ought to have the same standard for getting someone involved in the system. So while I'll support this, I guess Mr. Chaffetz has an amendment that would probably go a long ways in that direction, but it's certainly insufficient. And I would yield back to Mr. Polis. Thanks for yielding.
Yeah, I agree with the sentiments expressed by the gentlelady from California. Support the amendment, but very little practical impact that this amendment has. And I yield back the balance of my time.
Thank you, Mr. Polis. The question is on the amendment. All in favor say aye.
Aye.
Opposed, no. Ayes have it. The amendment is agreed to. The gentleman from Virginia,
Mr. Chairman, I think I'm right here. Sorry.
Yes.
I think I am going to go ahead and introduce amendment number 185, which is number 25 on the list.
The clerk will report Chaffetz number 185.
Amendment to the Smith Amendment offered by Mr. Chaffetz of Utah.
Without objection, the amendment will be considered as read and the gentleman is recognized.
Thank you, Mr. Chairman. This is a good follow-up. I'm very supportive of what we just did with Mr. Quayle's amendment. I think that's the right spirit in which we move forward. But I am compelled by what the gentlewoman from California said, too, which should be that what's good for the goose should also be good for the gander. We need to try to avoid situations where an order and injunction is issued simply primarily because the case would be too costly to defend. There are many issues why I think in principle this is right. We want to thwart the ability or the opportunity, or not necessarily the ability, but the motivation, if you will, for somebody to try to take advantage of this for something other than the purest of intentions and somebody who's trying to get true relief. And so I offer this amendment in the spirit of making sure that we're offering an incentive on both sides to inhibit somebody who wants to offer such, go into the courts, tie up the courts, the expense of the courts, the expense to defend, and to litigate this, and therefore I offer this amendment.
And the gentleman yields back his time. The gentleman from Virginia, Mr. Goodlatte, recognized.
Thank you, Mr. Chairman. Mr. Chairman, in this case, there's a very big difference between the goose and the gander. The goose that just got cooked is a plaintiff that knowingly misrepresents that an Internet site is dedicated to the theft of U.S. property. This one says that anyone who thinks they have a valid claim, including many people who act in good faith, are in a loser pays, and by the way, a one-sided loser pays situation. The amendment will discourage people from using the Section 103 remedy. If for whatever reason a judge remains unconvinced, then one would be on the hook to pay everybody's fees. It's an extreme version of loser pays. It's not limited to cases that should never have been brought or subject to other remedies. Such remedies already exist for fee awards and other sanctions in truly frivolous and abusive cases, e.g. Rule 11 of the Federal Rules of Civil Procedure, and in the amendment that was just adopted, offered by Mr. Quayle, for those who act knowingly and willfully. This amendment should be rejected because it is, in my opinion, designed to discourage people from using something that we're trying to make available as a remedy to go after these foreign sites that are infringing, and sometimes somebody will get it wrong. If they do, the court has other measures they can exercise. I don't think we should have an across-the-board requirement that if you don't prevail, you automatically are faced with all these fees.
Will the gentleman yield?
I yield.
I think in part you made my point that you have to be more than certain and confident if you're going to take the financial risk of moving forward with this. That is the point. So the idea that it would slow down the what could be an unbelievable array of suits and things that are brought forward into the courts, that is the point. And I thought, at least sitting over on this side, we liked loser pays. So
reclaiming my time, let me just say that I appreciate the gentleman's honesty, but that's not the standard that we apply to people bringing lawsuits in various courts for various types of actions across our country. While I have been a proponent of certain types of loser pays, this one that's one-sided, that only says that the plaintiff loses, he has to pay everything, is completely one-sided, number one. But number two, people attempting to avail themselves of access to the courts and on a reasonable basis should not be required to do this. People who act willfully to misrepresent the facts, absolutely, they should be required to do so. We just addressed that with Mr. Quayle's amendment. So I oppose this amendment. I think it is very extreme.
Mr. Chairman.
The gentleman yields back his time. The gentleman from North Carolina, Mr. Watt.
Mr. Chairman, I endorse all of the arguments that the chairman of the subcommittee has advanced, but I also want to just briefly advance one other argument, because the way this is drafted, even if there's a settlement of the dispute before you, if you don't ever end up with a court order or an injunction, then you still could be potentially on the line as the way this is drafted. So even if I supported it, it would need substantial work in the drafting. So I would just point that out, in addition to the arguments that Mr. Goodlatte has made. If there's going to be any equity in this, then it ought to work both ways. The winner ought to get fees. The loser ought to have to pay, and it ought to work both ways. But I don't think it ought to work either way in this case. It should just be left alone. And I yield to the gentleman from Virginia.
Thank you, Mr. Chairman. I'd like to support the gentleman from North Carolina and my colleague from Virginia. If you're going to make a good faith complaint, you ought not have to bet your house, which is essentially what this amendment would make you do. No person of any modest means could ever make a good faith complaint under this bill if this amendment is adopted. So I would hope it would be defeated and yield back to.
And I would just point out that one of the most egregious cases that I've heard is the woman who won the National Book Award, who's never made a dime from any of her stuff because it's all been put up on the web. And I mean, there are cases like that of people of modest means. And under this amendment, even if they went in and filed a lawsuit and it got resolved, they could potentially end up owing a bunch of money. So I just think this is a bad idea, and I yield back.
Mr. Chairman?
The gentleman yields back. The gentlewoman from California, Ms. Lofgren, is recognized.
Move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Here's why I think we have to consider Mr. Chaffetz's amendment. I want to use the example that we gave to the Attorney General when he was here a short while ago. In that situation, you had the Recording Industry Association. There was an employee who complained to the Attorney General of infringement on the site of this hip-hop site. As it turned out, the RIAA didn't own the copyright. They didn't actually have any information about the infringement. And as it turned out, if the news article is correct, and I haven't seen that it isn't, the site wasn't infringing. In fact, although it was seized for an entire year by the Department of Justice, no action actually was taken. They never actually moved forward because it wasn't infringing. The material that was being released had been provided to the website by the artists themselves to be distributed as kind of a teaser on the internet. There wasn't any infringement. That situation where you have an allegation that where there's no ownership of a copyright, there's no actual information of infringement, there is no, in fact, no infringement, would not violate the willful standard that was adopted by Mr. Quayle's amendment. There needs to be some deterrent for that type of activity. And I think that if you have, you know...
The gentlelady, I'm sorry, I didn't mean to interrupt you in mid-sentence. Whenever you get a chance. Sorry.
You need to have a basis. I mean, this is what you're seeking is internet death. I mean, take down the site, disappear you, and there needs to be some strong belief and evidence that that death penalty should be pursued. And because it's going to take money to defend, it is an extreme remedy, and the willful standard that was adopted by Mr. Quayle's amendment is not going to get to it. I haven't, you know, I'm hearing the criticism of Mr. Chaffetz's amendment, but I haven't seen a better amendment proposed that would put some kind of minder on the kind of abuse that we will, in fact, I'm sure see in a minute, that I'm sure we will see if this manager's amendment is adopted without some changes. Now, I would be happy to yield to my colleague from North Carolina.
I just want to direct the gentlelady's attention to page 28, the definition of qualifying plaintiff. I think addresses the concern that she's raised, and if we need to make it clearer, perhaps we could make it clearer, but I don't think that RIAA would have standing to litigate this case anymore under this under the standard that's in the manager's amendment, because I just don't think they would qualify. So maybe I'm wrong, and if I am wrong, then we ought to work on that, but we shouldn't go at it in the way that Mr. Chaffetz's amendment.
Well, if reclaiming my time, I was using the hip hop site as an example, which is not covered by the willfulness standard. In fact, putting aside the ownership issue, go to the question of infringement. There was an allegation of infringement, and there was no infringement. Action was taken to the detriment of the site for a year in secret. I realize there's a different process in mind in this bill. I'm using that as an example for the kind of mischief that can, in fact, occur without some kind of counterweight to the ability to proceed. I don't know that Mr. Chaffetz's amendment is perfect, but I haven't seen anything else that provides any kind of deterrent to improper proceedings under the Act, and I therefore would be inclined to support it. I don't know if Mr. Chaffetz wishes to address the issue, but I think that it is at least an opportunity to put the brakes on misbehavior. I haven't seen any other amendments that would accomplish that in the same way. And with that, unless Mr. Chaffetz wants additional time, I would yield to Mr. Paulus.
I think I'll just get my own time. If you,
then I would yield back.
The gentlewoman's time has expired. Are there other individuals who wish to be recognized? The gentleman from Colorado, Mr. Paulus.
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized for 5 minutes.
You know, I'm somebody who's generally, cautious about these loser bears all cost fees. I mean, they have their role. You don't want to use them everywhere. But there's something that's at stake in this particular debate, and generally with our legal system, and that's the ability of the big to bully the small through legal fees, without regard to the justice of the matter, without regard to the finding of a court. For a small entity to afford to see something through a trial, hundreds of thousands of dollars, could even be millions of dollars. Very, very difficult. We have a lot of large actors that are active on this bill. Now, clearly, his amendment has implications for large actors as well, implications that I support. But in particular, it's necessary for the tens of thousands of garage startups that, again, if they're confident that they can defeat an action, would have the ability to recover court costs from their bullier, as the case may be. It's an unfortunate reality that our legal system can and is used to bully, not just in the name of intellectual property, but a wide variety of areas of law where this has become a problem. And this bill, absent this amendment, could very well lead to more of that, again, without regards to the merits upon which the cases are decided. So I think it's very appropriate in this case, both for the large companies in the battles of the titans, which need to wind their way through the courts, but even more importantly, for the smaller operators and the startups and those for whom the legal fees themselves are substantial and difficult. This is a much stronger version, again, and really the language that was adopted already by this committee was seldom and very minor ever to have any impact on this bill. Willful use. The standard of Mr. Chaffetz's amendment in terms of the loser pays if in fact no order of injunction is issued is much more reasonable and will lead to at least a calibration, an equation within those who would seek to enforce their intellectual property rights about whether they have the chance to succeed or not. And they will not move forward if in fact they know that they are likely not to succeed and are only seeking to use the necessary legal fees that the defendant would otherwise incur as a bullying tactic to get them to conform to their desires. So I think this is a very appropriate component of this bill, and I'm happy to lend my support to that.
Will the gentleman yield?
I'll be happy to yield.
I appreciate the support and the position of this. I think in principle this is right. In principle, we ought to be standing for loser pays. There is a remedy in the court. It should be a high standard and a high bar. We're talking about dramatic action and taking down a website, and somebody may ultimately prevail, but if there isn't that barrier to entry to get in and start filing these by the thousands, I think we're going to see something that none of us intend. I think in principle this is right, Mr. Chairman, and that's why I would encourage my colleagues to take a serious look at this and look at supporting the loser pays provision that I offer in this amendment.
Thank you. And, you know, again, in terms of a small operating company, a website, they might, employ 10 people, 15 people. For them to muster the legal fees and make the case could very well be putting their entire company on the line, using all of their revenues, all of their investment that's been made in the company to be able to make the defense. And it's very reasonable, given that the process of making the defense itself could jeopardize their existence of a business, even if they are they succeed, that they would be able to recover those expenses. Again, it will cause those who would seek to enforce long shot suits, again, short of you willfully wielding this weapon, but a long shot. The willful window is very narrow. Even if there's a 5 or 10% chance of winning, this could be used very broadly in cases where 9 out of 10 times the defendant prevails, but is nevertheless put out of business by the legal fees that are incurred in the process of rightfully defending their claim that eventually gets adjudicated. So I think it's an excellent amendment, and I do support it. I yield back.
Thank you, Mr. Post. The gentleman from California, Mr. Berman, is recognized.
Yeah. Now, I understand the notion of the large company that owns copyrights against the poor, small, foreign rogue website. But you can turn it around the other way, too. What about that small independent production company that puts together its first movie and it's on the internet on these sites on day one, and the costs they have of bringing an action? What about the self-published book that...
Will the gentleman yield?
I will after I finish. Finishes publishing their book and finds it distributed and disseminated to millions of people. What about the songwriter and the recording artist who put together a song on a small independent label? Small versus large works both ways. Sometimes the parties that are interested, I know about the small search engines as well, and so I would yield. It works both ways.
I appreciate you yielding. If they're right and they win, they're not going to be liable for the costs. So in both examples that you gave me, they're right.
All I know is you do this, and people who are right and are concerned about any litigation and the probabilities of what happens will be deterred from exercising the rights. You're right. The surest way to shut down these cases is to adopt a provision like this and disincentivize a well-meaning, good faith, small copyright owner with perhaps their first movie or their first song or their first book from exercising their rights. I urge a no vote.
Would the gentleman yield?
The gentleman yields back his time or yields to the gentleman?
Yes, sure.
Thank you. This amendment would go far beyond the award of reasonable attorney's fees. It would provide for the reasonable attorney's fees of all parties to the litigation and of all witnesses, including experts, whether or not compelled by process or not. And so this is an open invitation for the defense in such an action to overload the plaintiff with possible costs, which would be a great deterrent for the plaintiff to actually even bring the case. So it's just unlimited opportunity within the scope of this amendment to prevent parties from being able to take their matter to court. So I'm going to, I think that this is too broad.
I'm with you. I yield back.
And gentleman yields back his time. The question is on the amendment. All in favor say aye.
Aye.
Opposed, no.
No.
Opinion share, the noes have it.
Mr. Chairman, I'd ask for a recorded vote.
Recorded vote has been requested. The clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Gallagly votes no. Mr. Goodlatte? Mr. Goodlatte votes no. Mr. Lundgren? Mr. Shabbat? Mr. Issa? Mr. Issa votes yes. Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Jordan votes aye. Mr. Poe? Mr. Chiefitz? Mr. Chiefitz votes aye. Mr. Griffin? Mr. Griffin votes no. Mr. Marino? Mr. Marino votes aye. Mr. Gowdy? Mr. Gowdy votes aye. Mr. Ross? Ms. Adams? Ms. Adams votes no. Mr. Quayle? Mr. Quayle votes aye. Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Berman? Mr. Berman votes no. Mr. Nadler? No. Mr. Nadler votes no. Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes no. Ms. Waters? Ms. Waters votes no. Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes no. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Ms. Sanchez votes no. Mr. Polis?
Aye.
Mr. Polis votes aye.
Gentleman from Ohio, Mr. Shabbat.
Mr. Shabbat votes no.
Gentlewoman from Florida. Gentlewoman from Florida, Ms. Adams. Oh, you already voted no. Gentleman from California.
Mr. Lundgren votes no.
Other members who wish to be recorded, the gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Clerk will report. Oops, the clerk will suspend. The gentleman from Michigan, Mr. Conyers.
Mr. Conyers votes no. Ms. Adams is recorded as no. Ms. Adams votes yes.
Clerk will report.
Mr. Chairman, 11 members voted aye, 22 members voted nay.
Majority having voted against the amendment is not agreed to. We will now go to the gentleman from Virginia. Oh, sorry, the gentleman from Arizona has another amendment.
Going to offer and withdraw?
No, Mr. Chairman, I withdraw that amendment.
Oh, thank you. Thank the gentleman from Arizona. We'll now go to the gentleman from Virginia.
He's going to go to the back. He's going to go. And that's deleted. So.
Okay, we'll now go to the gentleman from California, excuse me, ISA number 73.
Okay. If the clerk will read, I'll love to be recognized.
The clerk will report ISA amendment number 73.
Amendment to the amendment in the nature of a substitute to
Without objection, the amendment will be considered as read. The gentleman is recognized.
Thank you, Mr. Chairman. Now, I want to explain this very carefully. Normally, you'd be in favor of immunity. You'd say, wow, this is really good. But let's be practical. Without due process, granting immunity for everything tells companies essentially, don't fight it, just do it, and don't worry about due process, you have immunity. Our amendment leaves narrowly exemptions for, obviously, health and safety, but the fact is that an accused site should not find itself arbitrarily removed with no recourse, and more importantly, there's nobody here, I think, that is going to claim that I haven't been good for intellectual property, that I haven't worked on it. As a matter of fact, if I could ever get the chairman to move the Performance Act, we could move a long way toward providing compensation for what I consider an unlawful taking with Congress's help by terrestrial broadcasters. But having said that, the fact is, this, if not enacted, I predict, if not enacted, will simply cause the ISPs to go ahead and just cave in contract negotiations right off the bat before they ever start with all the intellectual property holders. It'd be like, oh yeah, we'll do that because we have immunity, and we'll just do it because you're not going to give us even the right to have lawful stuff unless we do this. I see it. It's a practical business matter. This immunity should be limited to health and safety, and in fact, due process should be available. Otherwise, again, this is something where it's not necessarily exactly what you'd normally do, but in this case, an overly wide immunity serves no real purpose when, in fact, due process is likely, and I'll say for the probably 35th time, the vast majority of the infringers are offshore, in this case 100%. Those infringers are not going to come in and claim anything. They're going to have default judgments. So it's not a situation in which they need to proactively be doing this. The fact is, I believe that this portion of the bill serves only to create an environment in which it is impossible to not say, sure, I'll go ahead, I've got immunity, and I think it's to the discrimination of fair due process for those who say they're not infringing. I'd yield to the gentlelady.
Thank you. I thank the gentleman for yielding. I think this amendment is not only important but essential. If you take a look at the underlying manager's amendment, as you pointed out, there's complete immunity on the part of anyone who acts in good faith based on credible evidence. Here's the problem in the manager's amendment. There's no process for actually testing that. It is to be narrowly tailored, but there's no process for testing that. There's no notice. There's no recourse, and there's no due process. And so, having complete immunity, if I were the payment processor, I've got a world of hurt if I don't agree, or I have complete immunity if I do agree. And the fact that someone says that it's a foreign infringing site doesn't mean that it's a foreign infringing site. And if there's no due process, it could be any site. So this is a huge hole in the bill. I would note that the bill that you have authored actually has some due process tests, so that you cut off the money, but at least you know that there's an opportunity to be heard, even on an expedited basis. You could act in a day, but at least there's going to be an opportunity to get to the bottom of it, which is not present here. Absent your amendment or something like it, we are going to have terrible abuses in this system. And I thank the gentleman for offering his amendment. It's a very
I thank the gentlelady in reclaiming my time. I might also note, with the demise of the previous two amendments, you could have an entity in the Cayman Island with no assets in the U.S. essentially making the claim. So you have a non-U.S. entity making a claim, and a U.S. entity going, well, I'm not going to bother because I've got this immunity. You could end up with an external entity creating an abuse in which it may not even really have the rights to the copyright, and yet all kinds of other foreign entities are shut down. And, Mr. Chairman, that would clearly create a trade problem with our trading partners if we started doing that as a practical matter, and it very much could happen. I yield back.
Thank you for yielding back. The gentleman from Virginia, Mr. Goodlatte, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I truly am looking forward to finding the ISA amendment that I can support. And looking down the list,
this could be it.
There may be hope, but this is definitely not it. He's heading in the wrong direction. This is a very bad idea. The gentleman's amendment limits the immunity provisions for voluntary action to those rogue websites that endanger consumer health or safety. This provision would ensure that no intermediary would take voluntary action against any rogue website outside the public health arena. Well, there are hundreds of thousands of jobs in the publishing industry, music industry, recording artists, motion picture industry, and they're nearly every brand holding corporation that sells any kind of product on the internet, unless it's related to consumer health or safety. It leaves all of those entities without any recourse to seek private sector solutions with intermediaries, and that's a bad idea. If we're trying to have this worked out without going to court, I think this is a very good safeguard that we need to give these folks who are being asked to intercede, and I would strongly oppose this.
Would the gentleman yield?
I would yield.
Well, maybe this will clear it up a little more and make it possible for you to see this in a narrower way. First of all, if a website or a provider, my brain has gone dead, if in fact you have a term of service already in your hosting arrangement, you can take them down based on that. So that would have immunity anyway. And under the DMCA, Digital Millennium Copyright Act, you also have those provisions. So one of the reasons that this is not as necessary as you might believe is, in fact, those two other carve-outs already exist. This is not as big a deal as you think. I understand that you're concerned that you wouldn't do it, but most of this is already covered by other areas. And when it's not, the real question is, why is it necessary to deny due process to a supposed rogue? You know, if we read the things said about us from the left or the right, depending upon your party, we're all rogue operators, according to somebody. The question is there going to be due process in this case?
Well, reclaiming my time, the fact of the matter is that rogue website in a foreign country has recourse against the complaining party. The issue here is what can be done by all those who are asked to intercede on their behalf in between, and they need to have liability limitation in order to be able to provide that kind of help to combat this kind of crime on the internet. And that's why I oppose your amendment. I certainly respect the fact that you're saying that if it involves consumer health or safety, that deserves some protection. But all of these jobs, all of these businesses, all of these people attempting to sell legitimate products on the internet are deserving of being able to go to these intermediaries and get the same kind of help, regardless of whether it involves health or safety or whether it involves hundreds of thousands of jobs in other sectors of our economy that are being lost, and billions of dollars in business are being lost because of rogue websites. And if you don't have the protection, you're not going to get it. So what you're going to do is you're going to protect that rare entity that may be, and it's a foreign entity, that may be sued improperly and still has a cause of action against the people who improperly sought the action, and you're going to deny all the legitimate businesses from availing themselves of the remedies of this law because of the fact that you have denied the people who could give them those remedies some limitation of their liability.
Would yield?
I will yield.
Well, you know, there but for the earlier amendment, I would agree with you. You understand, you've got this Cayman Island business with no U.S. assets that makes the claim, and they may or may not truly hold the actual copyright. So a very frivolous external act can...
So reclaiming my time, to go after the Cayman Island entity, you're going to deny all the legitimate U.S.-based companies with millions of U.S. employees losing billions of dollars on the internet, their protection under the law in order to get that one entity or a few entities or however many entities may operate through the Cayman Islands. And we've already talked about the merits of this situation because the committee rejected your idea that we should somehow have a different protection for U.S. entities than other entities here and give up the hope that in other countries we will get help in those countries in enforcing our intellectual property rights in those countries. I think that was a bad argument. You're compounding it with this argument, not helping it.
You know, the gentleman, I appreciate you're constantly yielding. I tried to protect U.S. entities and those jobs. That is not the definition in this bill. That's one of the problems. The second problem is that, in fact, this is working around the due process. There can be huge amounts of jobs on both sides. This is allowing an exception to due process, and we're not talking, as you know, we're not talking about the foreign site. We're talking about the domestic jobs that will be attacked by their exclusion in all likelihood.
The gentleman's time has expired. The gentleman from Virginia, Mr. Scott, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, there are actually jobs on both sides of this equation, and I'd rise in support of the amendment. Immunity counts when, oops, it shouldn't have come down to begin with. That's when you need to rely on immunity. So you've actually taken down a site that should not have been taken down. Now, if you're taking down a website, you're not only putting people out of business, you could be putting a business out of business. And we would hope that before you voluntarily put somebody out of business and take somebody's website down, that you do some modicum of due diligence. You should not be able to hide behind something that's facially apparently credible and just take somebody's website down based on that. You ought to do some due diligence. And it's not impossible to have a situation where you're actually talking about a competitor who looks and sees he can take down his competitor's website and make some more money, and then hide behind the immunity of something facially credible. The liability requires you to do due diligence to protect yourself from negligence. The gentleman from California's amendment preserves the public health emergency, so if there's a public health situation, you can go ahead and forget about due diligence.
Would the gentleman yield?
I yield.
The gentleman's time has expired.
Mr. Chairman, I ask unanimous consent that be given an additional 30 seconds.
The gentleman is recognized for an additional 30 seconds.
I just want to point out to the gentleman that the private rights of action in this bill do not include taking down anybody's website. That
I can't hear you.
I said the private rights of action in this bill, including these provisions, do not include taking down anybody's website.
Well, I mean, reclaiming my time.
That can only be done through the Justice Department.
Civil liability is what's at stake here, correct?
Well,
correct.
Well, the immunity means you've crimped somebody's style. You've been able to hurt their website, whatever you've done to them. You should not get immunity without any modicum of due diligence on your side. This immunity provides that if you have done no due diligence, you take some paper that's facially credible and not look behind it, and you've inflicted pain and suffering on somebody else's website. We should not give immunity to that, particularly in light of the fact that it could be a competitor and you have a financial interest in the transaction. I yield to the gentleman.
I thank the gentleman. Yesterday, I met with a gentleman from
the gentleman's time has expired.
Mr. Chairman?
Can I ask for an additional minute so we can finish?
Okay, the gentleman is recognized for an additional 30 seconds.
Thank you. Yesterday, I met with a gentleman from the chairman's district who hosts a server farm that hosts all kinds of sites. And he would be an exact example of somebody who, under the current language, would have every reason to say, you know what, I'm just going to cut off all these guys if there's any complaint, and I'm fine because I get immunity, and if I don't, I have a problem. So it will be denial of service the way it works for that particular individual who has to decide between just turning them all off and having immunity or dealing with the other outcome. He's going to probably make that choice. And it's one of the reasons he opposes this act in its current form.
Gentleman's time has again expired. The gentleman from North Carolina, Mr. Watt.
Thank you, Mr. Chairman. You don't often see me and Mr. Scott at odds with each other, but I'm at odds with him on this one, and for, I think, good reasons. I think he's misunderstanding what's happening here. First of all, the immunity, I'm not a big advocate of immunity, and the members of this committee know that I'm not a big advocate of immunity. I've talked against it on a number of occasions. But the immunity that's being provided here is being provided to people who are acting pursuant to a court order. This is not willy-nilly.
Will the gentleman yield?
Just
because I don't think that's correct, actually, in the language, is my understanding. This is not a court order. That would be, I'm proposing an amendment to do that I hope you support, but currently it's not. It's a standard of good faith and credibility.
All right. Well, but understand, it's not the people who are filing the lawsuit that are getting the immunity here, right? It's not the people who are getting. The list of people who are getting immunity is on page 41, starting at line 19. It's the service provider. It's the payment network provider. It's the internet advertising service. It's the advertiser. It's the internet search engine. It's the domain name registry, the domain name registrar, and people associated with them. It's not people who are bringing the lawsuit that we are giving any immunity to. In fact, I've been pretty aggressive in my belief that if somebody who brings the lawsuit really is out to lunch, they certainly ought not have immunity. But if the network is acting based on somebody else having initiated something, we ought not be asking them at the same time that we're asking them to cooperate and take down sites, saying you're going to be liable for doing what you have reasonably been asked to do. I'll yield to my friend from Virginia.
Well, the problem is if you take action based on something that, kind of looks credible and you inflict significant pain on somebody's website, you ought to do some modicum of due diligence, and without which you would be negligent. And this gives you immunity, so you can go inflict all the pain on them that you want and not worry about it.
No, but then you're arguing against yourself, because now you're saying that these people ought to be told to monitor the whole system, which is opposite of what we've been telling them, and what I thought my opponents to this bill were concerned about, at least initially. We've not asked these service providers or payment network providers to go and monitor anything. The person who ought to be diligent and not willy-nilly is the person who initiates the process in the first place. These are not the initiators of the process that we're giving immunity to. Now, so I want to make that argument. Second, I think we've got a reasonable and good balance here that if we take this immunity provision out, is going to upset the whole balance of the bill. And so for those two reasons, I have to rise in opposition to the amendment, even though I'm not a big supporter of giving immunity to anybody generally.
Mr. Chairman?
I yield back.
Thank you, Mr. Watt. The gentlewoman from California, Ms. Lofgren.
I move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Here's the problem and why the amendment should be approved. Mr. Watt is correct that the immunity is provided to a service provider, a payment network provider, internet advertising servicer, advertiser, internet search engine, domain name registry, domain name registrar, and the like. But it's voluntary action that is being requested of these entities. And if they take action to disappear a site, to cut off all the funds, they don't have any liability. Well, there's no monitor, there's no arbiter of the standards. On page 42, line 1 and 2, it talks about acting in good faith and based on credible evidence. But there's no court process to determine that that in fact is the case. Actually, those words are meaningless, because we all know that a right without a remedy is not a right. This will allow for dramatic, draconian action to be taken, suppressing competitors, suppressing free speech, without any real obligation, without any court test, and without any liability. This is really a problem. And I know that Mr. Polis has an amendment, and Mr. Scott had one too. I don't know which one is going to offer it. But without some capacity to test these tests in the Act, we will have abuse. Recently, I was asking one of the large internet companies about the nature of the DMCA takedowns that they are being asked to do. And the report I got, they act very quickly, but probably they said 20% of the DMCA notices they get are from competitors trying to destroy somebody on the internet. I mean, this is not like a made-up problem. This is a real problem. And if there isn't a due process here, we are going to have tremendous mischief here. And so the liability reduction, with the exception of health and safety, I think is a rational approach. The fact, this is not a lawsuit that's being brought by people who say they are aggrieved, whether they are aggrieved or not. This provides for all of these entities to take action on a voluntary basis. I had this described to me as the vigilante section of the bill, and I think actually that's a good way to think about it, because there really is there's no plaintiff, there's no court, it's just the ability to disappear things. And to think that cutting off money is a benign activity is completely false. It takes a lot of money to keep the bandwidth up for this website. You can't do it if there's no source. I mean, if there's no source of revenue, you've effectively inflicted the death penalty on a website, on a small business, without ever having any access, not only to due process, they don't even have to be notified under this action. It's just the next thing they know, there's no money. I mean, how we would think that that would be a reasonable approach to infringement is just stunning. We cannot allow this to be part of the bill, and I am absolutely certain that if this is not altered, it will be abused, and the members of this committee will regret it very much, because there will be many jobs lost, many rights lost if this is not remedied. And with that, I would yield to the gentlelady from...
The gentleman from California, Mr. Berman, is recognized.
Strike the last word, Mr.
The
Chairman.
gentleman is recognized for 5 minutes.
Memories are so short. In the Digital Millennium Copyright Act, the ISPs and all the other groups that came in said, we will not support this unless we get immunity. And the deal that many people, and Mr. Goodlatte was directly involved in this at the time, and a number of us on the committee, was to give what the ISP requested so that notice and takedown would work, so because they had immunity. The Communications Decency Act, which we all supported, provides immunity to intermediaries and protections so that they will do what we wanted them to do, to deal with indecent materials. The requirement of good faith based on credible evidence is not a standard for a lawsuit, but it's a standard to decide whether the party can be sued in a lawsuit. The provision Ms. Lofgren read and cited, no action may be brought if, for these things, if it's operated based on good faith and credible evidence. The party who has been granted immunity can assert the immunity, but only if they can, against a lawsuit against them, but only if they can establish they had credible evidence and their action was based on good faith. Let me talk about a personal story. There was a Russian website, allofmymp3.com, filled with tens of thousands of illegal sound recordings, perfect copies of copyrighted works, American works, on their website, and you could buy them for 10 cents, each one for 10 cents. And Visa allowed their credit card to be used to purchase these, and they weren't paying royalties to anybody, they didn't have the rights, and I met with them several times and said, why are you facilitating the use of this rogue website, then the sort of functional equivalent of Pirates Bay? And the first meeting and the end thing, we had a second meeting, a third meeting. They finally took it down. A Russian bank then sued them because they were the banker for these transactions with this rogue website. You have the protections by the way this is written. Let me tell you, if this amendment passes, it massively upsets the whole balance in this legislation. And for the people who are now arguing don't grant immunity, who 10, 12 years ago came in saying we will only operate if we have immunity, the ISPs and all those folks, to twist this around now to try and unbalance and defeat this bill, I think should be pointed out.
Would the gentleman yield?
Sure.
Well, you know, normally balances between two sides. I'm trying to figure out if having this bill leave the Digital Millennium Copyright Act and all those other things intact, we're not taking that away. If limiting it to that, I just want to know, I'm trying to figure out who you balance with, because as far as I could tell, this is all one side.
This is not. The question is, will the credit card company, when presented with information that allows them, that they find to be credible, and in good faith decides to quit facilitating payments to a foreign website, a foreign, not a U.S., a foreign website, and that website will sue them. The question is, should they have immunity if they're doing it based on good faith, belief, and credible evidence? And if they don't, if they don't have that, they'll never stop facilitating it, no matter what information they're given. So, and the gentlelady from California says, but this won't be tested by a court. But the answer is it will be, because when they are, if the website was really a legitimate one and sues them, and they can't establish that they had credible evidence and a good faith belief, they don't get the immunity. So this will ultimately be litigated if it was a frivolous automatic yanking of the credit card with no justification whatsoever. So I urge a no vote on the amendment. Yes.
If you have operated in good faith and done due diligence and made a credible decision in those cases, what liability is there to get immunity from?
The gentleman is recognized for an additional 30 seconds.
And to answer that, they won't sit there and say, I know I'll win that lawsuit at the end of the day, and I'm willing to spend all the money to hire the lawyers to make that case. I will win that. They just won't pull the credit card from that foreign rogue website. And so without the immunity, this process doesn't work. And everybody knows it because that was the key that made the Digital Millennium Copyright Act pass. And if Mr. Goodlatte wanted to weigh in on this because he was so involved in negotiating that, am I wrong?
Gentleman is absolutely right, and that immunity exists today, and it's good immunity. It has been what has assured a lot of the companies involved in helping to enforce copyright law today that they take the actions they take under the limited laws that exist today. It needs to be in this new law as well. If it's not, the gentleman's correct. It won't work.
The gentleman's time has expired. The gentlewoman from Texas, Ms. Jackson, please.
Thank you very much, Mr. Chairman. I almost wonder if we are expressing a concern about the legislation, do we have an opportunity to pass any amendment? I also wanted to make sure that while Mr. King was in the room, I shared my voice with him again so that he could be as excited as he was in the past. I look forward to talking with him, Mr. King, about your Twitter account. But let me just say that I associate with Mr. Scott's comments. My general comments are that you are looking at, in the instance of the example of Mr. Berman, that's a big entity. I can't imagine that they would be so frightened in doing the right thing. And they have the ability to withstand any onslaught. I think the gentleman from California's amendment gives me comfort because it eliminates the ability of being judge and jury, that you are able to, in essence, knock entities off and have no recrimination at all. So I think that it has value from that perspective, and I think there's sufficient, when you have all of these elements being listed, I think that you have great concern when you list service providers, payment net providers. All these people are getting immunity, and the little guys that they may knock off, they'll never get back on again. They'll be the judge, the jury, and they'll be pounding their chests, and they'll be saying, I have immunity, I can do this. Little guys never heard from again, and by mistake, by the fact that I have an amendment that talks about certification, but you never hear from them again. So I would suggest that Visa should be reprimanded. Let me just not use their terminology, but a company of that size should be reprimanded for not doing the right thing. I frankly think they should be doing the right thing, but this structure that you have gives too much power to one entity. I'd be happy to yield to the gentleman from California.
I thank the gentlelady, and I appreciate her support of this thoughtful amendment. Well, at least I thought it was a good amendment. The question that keeps coming to my mind that hopefully we can all ask in order to vote for this is, if no service provider, no search engine, none of these people are saying they want this, and we haven't had a hearing to hold them to task for what they can and are already doing under existing laws, what more they could do, then don't we get back to that same question that We haven't heard enough. There are certainly, at least at a subcommittee, Mr. Chairman, we should be able to have more of these witnesses come in. We should be able to ask them. The gentleman who's such a large employer in the chairman's district, with his cloud sites, we could have him in here to say, what's the practical reality of this? How would you do it? What would you do? We haven't had that, and that's one of the limitations of the legislation we're considering here, is an absence of any kind of both classified and unclassified research. And I know that the chairman has worked diligently, but he's worked in a comparative vacuum, and some of the amendments that are in the manager's amendment speak to that one hearing made that great a change. Just imagine what 2 or 3 more hearings might do to both acceptance of some of our amendments and amending of some of our amendments. And I thank the gentlelady from Texas for yielding the time, because this is an important amendment. It certainly would go a long way to having people be more comfortable that we're doing no harm.
Claiming my time, and I'll be happy to yield to the gentleman from Virginia in just a moment, but I want to follow up on the inquiry that the gentleman from California made and just inquire of my chairman, my fellow alumnus, if I might. Mr. Chairman, the Senate bill, as I understand it, is slightly different from ours. So if this bill possibly goes to the floor, there is typically an opportunity for a manager's amendment. What I've asked is that those of us who have expressed concerns not be held to a standard of not getting any of our thoughts included. Do you intend to, or would you welcome the opportunity for dialogue on a manager's amendment as it goes to the floor, if we get to that point, that takes into consideration some of the many thoughts that have been offered here that may not have prevailed at this point?
Yeah. The gentleman will yield. Of course, I'll be happy to continue the dialogue, and that's her word, and deal with some of these issues in a good faith manner. Again, I can't make any promises, and I don't want to judge them on the number of amendments that have been offered, but on their merits or demerits. But I'll be happy to discuss any issue with the gentlewoman between now and the House floor when that time comes.
Let me thank the gentleman. I'll take that as a positive step for a manager's amendment going to the floor, and I yield to the gentleman from Virginia for a moment.
Thank you. And I'd like to respond to the gentleman from California who brought up the point that we've done this before, therefore we should do it again. It might have been a bad idea before. We ought to debate it individually, and if it's a good idea, if it's a bad idea to have this immunity in this
The gentlewoman's time from Texas has expired.
Could you have 15 additional seconds?
Yes.
Would you yield me additional 30 seconds, Mr. Chairman?
The gentleman or gentlewoman is recognized for an additional 30 seconds.
I thank the gentleman. I'll yield the 15 seconds to the gentleman.
And also, if there, and I think I interpreted the comments, if you've done a good job based on good faith and credible evidence, there is no liability.
And I thank you very much. And Mr. Chairman, I'll end on the happy note that I started. I've lost Mr. King again, but I'm looking forward to us getting together on making sure that he stays happy in these hearings. I yield back.
The gentlelady would yield.
The
gentlelady would yield.
I'd be happy to yield.
I've been informed by the gentleman that he'll come back out anytime you call his name. The
gentleman's time has expired. The question is on.
I yield back.
Question is on
Mr.
the
Chair,
amendment.
Mr. Chair, I move to strike the last word.
Who seeks recognition? The gentleman from Colorado is recognized.
Thank you. A couple points in hearing this debate. First of all, in the Digital Millennial Copyrights Act, Congress carefully put in a counter notice process that specifically protected due process. I really want to draw my colleagues' attention on this committee to Section 105, because in a bill that many of us on this committee don't agree with, I would argue that this is the worst single provision, and one that needs to be fixed. There's a couple different amendments to do it. I support them all. We'll be talking about, I think, one of mine soon that will require a court order. Ms. Lofgren has one. Mr. Ice's is very simple. But here's what's fundamentally wrong. This is a completely one-sided takedown. Anybody could construct a letter that looks like it's nice on good faith and based on credible evidence. I'm not even an attorney. And I could play corporate counsel and write something that a web hosting company would look at, and it would look reasonable, because I'll just attach a few pages of data. And what do they know about this? They host tens of thousands of sites. They get this letter on the one side of the equation, take it down, no liability. Other side of the equation, they don't take it down, they don't know. I mean, and they don't want to devote the resources to it, because I'm paying them $100 a month. What's it worth to them? $1,000 a month. What's it worth to them? $10,000 a month. What's it worth to them? So this rules out any calculus that even they make. This doesn't require a court order. There's no ability to respond like there is in the Digital Millennial Copyrights Act. This is a provision that is simply completely one-sided and unfair, and can absolutely, as my colleague Mr. Scott pointed out, be used in an anti-competitive way.
Gentleman, yield.
I'll yield for a moment. Sure, Mr. Watt. Yes.
I'm still not convinced that a court order is not required.
Well, it's a factual matter that it's not required. I mean, reclaiming my time, maybe the gentleman can support my amendment, which will then clearly specify that a court order is required, but I don't see any language in here that says a court order is required.
Well, the gentleman yields.
Well,
yes, I'll further yield to the gentleman.
The gentleman from Colorado has the time.
I yield.
We're taking this. In the original bill, there was private action that could be taken without a court order. There was action that could be taken. But all that stuff got dropped.
Reclaiming my time, I'm not referring to the original bill. We're talking about the manager's amendment, and we're talking about how a web hosting company can get complete immunity, and they can do it very simply by responding to just a nice, thoughtful letter that looks on credible evidence without any recourse. So they get a letter, by the way, you're infringing on this copyright I have. They then have a choice. They can either take it down, in which case they're completely immune, regardless of the merits, or they can say, no, we're going to keep it up, and even though we are not immune if we keep it up. So, I mean, there is no balance. There is no requirement for a court order. All it takes is a halfway competent corporate counsel to take out almost any website that there is. I'll be happy to yield to my friend from Florida.
I thank the gentleman, and I just, for clarification purposes, we've been talking about lots of different sections. We're talking about Section 105?
Yes.
And subsection A?
Yeah.
I'd just like to walk through this so that I understand this the same way that you do. Section 105, this is actions taken consistent with the purposes of this title. Is that right?
That's correct.
No cause of action shall lie in any federal or state court or administrative agency, and then walks through who this applies to. And then it says, including director, officers, employees, or agents of any such entity, only for taking the actions described in Section 102C2 or Section 103C2.
Mm-hmm.
Section 103C2 talks about reasonable measures after being served with a copy of an order under the subsection. And the earlier section has the same language. We're not speaking of a court order?
No, and if the gentleman agrees to include, again, my amendment will be up shortly. This amendment fixes it. The gentleman is welcome to support my amendment, which simply requires a court order for this section.
Would the gentleman yield for just 1 second?
I'll be happy to yield to the gentleman from California.
If it helps in this debate, I certainly would be glad to suspend this amendment until Mr. Paulus's amendment is heard next out of order, so that we could establish that it would be a court order, and it might make mine less onerous to everybody, but we can't be arguing something in a bill in a vacuum, vote mine down, and then turn around and vote his down, which is what I fear.
And reclaiming my time, I think this speaks to the rush fashion that this bill has been brought forward. Again, there is no mention of any requirement for a court order. There is clear immunity for one course of action and not for the other course of action.
The gentleman yields.
And again, a sin of omission being just as bad as a sin of commission, just as we want to take down any illegal content as quickly as possible, so too we don't want to encourage taking down legal content that doesn't violate any copyright. So
gentleman's time has
if the gentleman from Florida will support my amendment.
The gentleman from Florida is recognized.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
In section, this provision that we're talking about, Section 105, refers back to the earlier Section 102C2. Section 102C1 refers to a copy of a court order. Section 102C2 refers to, has language saying after being served with a copy of an order under paragraph 1, that's a court order.
Will the gentleman yield?
Let me finish. And when, even in the absence of any of that language, we're failing to fully read what's in this section and when this immunity would apply. If you look at the further defining language, at first it talks about those two provisions and the orders required thereunder. Then it talks about the requirement of acting in good faith based on credible evidence. Then it goes on to say that, number one, the Internet site is a foreign infringing site, is an Internet site dedicated to theft,
which is what you'd like to strike, and subsection 2, the action is narrowly tailored and consistent with the entity's terms of service or other contractual rights and with the purposes of this title. We seem to be missing the fact that any action that is taken here would have to be taken under the terms of service, the terms of service presumably being very clear that in any of these companies, as I understand from speaking with them, because though they're not here this evening, as everyone seems to suggest they would like, in speaking with them, it's clear that the terms of service in virtually every one of these contracts would prohibit exactly the kind of theft and intellectual property theft that we're getting at. They have to be consistent with that as well. We need to read this in full. We can't pick and choose. We need to look at all of the language, and it is in looking at all of the language that I oppose this amendment.
Will the gentleman yield?
I will.
Okay. Again, the language that was cited only for taking the actions described in Section 102. Again, the actions of those operative sections of the bill, not the pre-requirements of the operative sections of the bill. It refers to the actions described in that section of the bill.
The actions taken under that language pursuant to the order that causes the action to be taken.
Well, if the gentleman agrees that that is the intent of the bill, it is at best ambiguous, but we can clarify it with my amendment, which would very clearly apply a court order language to this part of the bill. If that's the intent, there shouldn't be.
I actually reclaiming my time. One, I don't think it's unclear. Two, I think that you continue to ignore the second subsection, which talks about the additional requirements that will be contained in the terms of service agreement, which would forbid the very action that we're trying to get at. We're simply requiring that they take action consistent with their own terms of service and granting immunity if they take that narrow action based on what is required. And I yield back.
Chairman yields back his time. The question is on the amendment. All in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it. Recorded vote has been requested. Clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble?
What are we saying about this?
Mr. Gallagly?
He was saying that he's concerned.
Mr. Goodlatte? Mr. Goodlatte votes no. Mr. Lundgren? Mr. Shabbat? Mr. Issa? Mr. Issa votes yes. Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Griffin? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? Ms. Adams? Ms. Adams votes no. Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Amade votes no. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Berman? No. Mr. Berman votes no. Mr. Nadler? No. Mr. Nadler votes no. Mr. Scott? Mr. Scott votes aye. Mr. Watt?
No.
Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Ms. Sanchez votes no. Mr. Polis?
Aye.
Mr. Polis votes aye.
Gentleman from Arkansas.
Mr. Griffin votes no.
Gentleman from Ohio.
Mr. Shabbat votes no.
Gentleman from California.
Mr. Gallagher votes no.
The other gentleman from California, Mr. Lundgren.
Mr. Lundgren votes no.
Other members who wish to be recorded. The clerk will report.
Mr. Chairman, 10 members voted aye, 24 members voted nay.
Majority having voted against the amendment is not agreed to.
Mr. Chairman? Mr. Chairman?
Yes, for what purpose does the gentleman from Utah seek to be recognized?
I was considering asking for an adjournment vote, but I thought maybe I'd get some advice on that before I actually called for that vote.
Thank you for asking for advice. I'd request that you hold off for a little bit longer.
Okay, Mr. Chairman, could we define a little bit longer?
How about 10 amendments?
No.
Mr. Chairman, did you say 10 amendments or 10 minutes?
Very good. I'll take the gentleman's suggestion under consideration. Let's proceed for a little bit longer.
What?
Let's see how it goes. The gentlewoman from California has an amendment.
Mr. Chairman, if I may, I would suggest that we go to Mr. Paulus's amendment, because if that were adopted, it might obviate the need for me to offer these next two amendments.
Mr. Chair, I have an amendment at the desk, amendment number 85.
The gentleman has not yet been recognized.
Mr. Chairman, I have an amendment that's listed next, and I think Mr. Paulus's amendment would clear up the issue.
Right. So we should go.
That goes to, she said she's going to four dollars now. She goes to end of the
She go to the bottom of the bucket, but they want to get to the fullest.
Yeah. Do we want to do that now?
I think Mr.
Let's talk about it. The gentlewoman from California's two amendments then will come at the end of the section.
Well, I would offer them only if Mr. Paulus's amendment is not adopted.
No, we will go to his amendment. I'm just saying the result of your forfeiting, offering your amendments right now will take you to the end of the section. I don't think that's going to be an impediment.
Well, I have several other at the end of the section,
so it's not to your disadvantage.
No, it's fine.
The gentleman from Colorado is recognized to offer an amendment.
Thank you, Mr. Chair. Along with Mr. Scott, I have an amendment at the desk.
We're going to take up your amendment. I don't think we can take up both at the same time.
I'm a co-sponsor of his amendment.
Oh, I'm sorry. Okay.
Context.
The clerk will report Paulus number 85, co-sponsored by the gentleman from Virginia.
Amendment to the Smith Amendment offered by Mr. Paulus of Colorado and Mr. Scott. Page 41, line 25, insert
Without
after.
objection, the amendment will be considered as read. The gentleman is recognized.
Thank you. This amendment, I think, again, with due respect to my colleague, Mr. Rice from California, I think this is a more appropriate and less ideological fix than eliminating the section. Again, I did support that. What this would do is simply add a control pursuant to a court order. Now, my colleague, Mr. Deutsch from Florida, argued that that was already the case. I don't believe it is, because it only recurs to the actions of a previous session, not a court order. If it is, there shouldn't be any problem at all, including this amendment. But I think we again, there are great legal scholars, and if they disagree, I encourage them to speak up on this committee. But it is my reading that there is currently no court order that is required. It is effectively immunity if there is credibility and good faith in the view of the person who receives the notice. Again, as we have argued in the course of the last amendment, that is in no way, shape, or form a sufficient standard. Any halfway competent corporate counsel can wield this as an anti-competitive weapon under the current language and simply put a few statistics on a piece of paper, put some nice words, and it'll look reasonably credible and in good faith, because the recipient of the notice, which may be a hosting service or an ISP, isn't in the business of assessing the merits of copyrights. I mean, what do they know? They get a notice. They have a legal compliance department. They get this notice. It looks like it's written by a lawyer. It looks halfway decent. And if this law were operative, absent my amendment, if they take down the site that could be infringing or might not be infringing, there is zero legal liability. If they don't take it down, then they could be subject, if it, in fact it is an infringing site, to the reach of the law. So they should have to turn to a court order issued according to Section 102B5 or Section 103B5. That some court somewhere in the country, through a TRO, through a preliminary injunction, through a permanent injunction, has found this claim of infringement to have some merit. Absent some check on whether there is any merit at all with regards to the claim, it is simply an enormous competitive advantage for those among the companies who are the most well-lawyered. Again, this does not work to the detriment of the internet service providers or the web hosting companies. They might lose a customer here or there, but they gain immunity. This does work to the detriment of those whose websites are wrongfully taken down. And again, there are different types of public policy failures. An analogy that this committee is all too familiar with is voting rights. It is wrong, as those on the other side of the aisle like to point out, for people who are ineligible to vote to cast a ballot. That is wrong. It is also wrong, as those on my side of the aisle like to point out, to deny the franchise to those who are eligible. Those are both true. Neither one takes precedence. It is just as wrong to deny the franchise to someone who has the right to vote as it is to allow someone to vote.
The committee is not in order. I think the gentleman has a right to be heard.
Thank you.
The gentleman is correct. The gentleman will proceed.
Thank you. And again, this is, without a doubt, the most important and most onerous piece of this bill because it has no legal checks whatsoever. My amendment would apply a common sense legal check, which Mr. Deutsch has said is arguably part of it already, although in my reading it is not, and make it clear that in fact there has to be some court order, TRO, preliminary injunction, permanent injunction, that would then afford the immunity for the takedown. So it has gone through some court that has had to found some merit, and then it would be taken down and the immunity would be invoked. I do agree that immunity in that case, if there is a court order, can be appropriate. We do have that under the Digital Millennial Copyrights Act, although we do have a right of response under this. And likewise, if we made it pursuant to a court order, there would also be a built-in right of response because the court order has a right of response to be reacted to. This change that I propose would really comfort to a great degree many of those who have expressed vociferous concerns about this section of the bill because it provides some control on what is otherwise a completely one-sided provision that puts immense power in the hands of any halfway competent corporate counsel to a rights holder to the complete detriment of websites who would be wrongfully affected, many of whom might be enabling websites of user-generated content. Again, most of the potential violators we're talking about here is user-generated content. The website provider would simply be an enabling technology that might incidentally be used for an infringing purpose or even not incidentally used for an infringing purpose. But as long as the letter looks nice and has a bunch of pages of nice statistics, the clear course of action that any counsel to the hosting service will indicate would be take it down.
The gentleman's time has expired. The gentleman yields back. I'll recognize myself in opposition to the amendment. The gentleman's amendment would exclude the publishing industry from seeking relief under this bill. This would create a huge loophole in the bill that would allow sites that are clearly dedicated to infringement to simply place a handful of works that are in the public domain on their site and thus would delay the effective remedies provided under the bill. This provision also removes voluntary immunity for intermediaries that take action against a rogue website. Without this provision, intermediaries, even when the evidence is clear, would be unlikely to take action against any rogue website. Under the Manager's Amendment, there is already a very strong First Amendment savings clause that ensures that no order would be issued that violates the First Amendment. For these three reasons, I oppose the amendment. Yield back. Are there other members who wish to be heard on the amendment? The gentleman from California? The gentleman from California, Mr. Berman, is recognized.
Mr. Chairman, I oppose the amendment, and I want to go back. I happen to agree with the gentleman from Colorado's interpretation of this language with respect to court orders or not. But the two things I disagree with him about are, one, that pursuant to a court order, you need immunity. That's the last place you need immunity. If you're ordered to do something, you don't have to be you're not going to be subject to suit because you did something the court ordered you to do. So you don't need an immunity in that situation, number one. And number two, Mr. Polis's summary dismissal of the Digital Millennium copyright provisions. A company sends a copyright owner sends a letter to an ISP that asks him to take down this particular infringing thing from a website that ISP links to. Some ISPs may go to the website, others don't. But the immunity is whether you go or don't go. And there was the ISPs that insisted on it for obvious reasons, because they didn't want to face a barrage of lawsuits about all of this stuff. And I don't know what you were talking about with respect to counter notices or anything else. All I know is, as I understand the Digital Millennium Copyright Act, you don't have to give notice to the website of whether that was an infringing piece or not. The ISP can take it down when they get the notice, and they're given immunity for doing that. And I consider this to be quite analogous to that situation. And I know that we will never get people who are facilitating the purchase of infringing material from only foreign websites if we don't provide that immunity. So this provision is fundamental to the structure of the bill. Now, I've heard this is the most odious part of the whole bill. I haven't heard that argument used since we were dealing with the issue of the security of the Internet, which was the most odious part of this bill. But I just think this is fundamental to the fabric of dealing with the problem of getting infringing material off of websites, getting rogue websites that, as defined in this bill, that are dedicated to the dissemination of and the distribution of infringing material, and getting people who facilitate through advertising or through utilizing credit cards payment by consumers for illegally distributed material. So, and to me, this is the analogous next step to what we did in the Digital Millennium Copyright Act, and I don't understand the gentleman's distinction between the two.
Thank you, Mr. Berman. The gentleman yields back. Any other member wish to be recognized on the amendment? The gentleman from